217/2015 by order dated by learned additional Chief Judicial Magistrate Morrigaon, which was upheld with certain modification by the Court of Learned Sessions Judge Morrigaon in Criminal Appeal number
5/2020.
5/2021. Issue notice to the respondents. As learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice by registered post with AD within 3 days from the date of this order, returnable after 4 weeks. As the petitioner is on bail granted by the First Appellate Court also granted you bail.
That's what I'm not. My lord, that's what.
Bail granted by the lower court, and as he has been punished only for a period of 3 years, the operation of sentence imposed on the petitioner by the impugned judgment shall remain suspended till the returnable date. Let this matter be listed accordingly.
Obliged, my lord.
My lord, this case pertains to NI Act. And by way of this revision petition, my lord, I'm assailing the order dated 21/11/2023, passed by the learned appellate court, whereby my appeal against conviction and fine was dismissed for non-prosecution, my lord.
Dismissed for
Non-prosecution, my lord. The mandate of the law is clear, my lord. Criminal appeal has to be disposed of on merit.
And so the trial court order is maintained.
Yes, my lord.
You are in jail.
No, I'm not in jail, my lord. I'm on previous bail, my lord.
Granted by?
Granted by appellate court, my lord.
Third, Mr. J. Bora, learned
My
counsel.
lord, it's N. Patiri.
Third, Mr. N. Patiri.
Patiri, P-A-T-I-R.
N. Patiri, learned counsel for the petitioner. Also heard Mr. P. Bhattakur. This application under section 401/397 of the Code of Criminal Procedure, 1973, has been preferred by the petitioner Shri Prabhas Patwari, impugning the judgment and order, impugning the order dated 21/11/2023, passed by learned additional session judge number 5, Kamrup Metro, whereby the appeal preferred by the present petitioner against the judgment and order dated 18/2/2020, passed by London Judicial Magistrate First Class Kamrup Metro in CR case number 4200C/2013 was dismissed for default of the petitioner. Stop. By the judgment of the London Trial Court, the petitioner was convicted under section 138 of the Negotiable Instrument Act and was sentenced to undergo simple imprisonment for 6 months and to pay a compensation of ₹13 lakh only to the respondent, and in default of payment of compensation to undergo simple imprisonment for 2 months. Issue notice to the respondents. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice needs to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice to respondent number 2 by registered post with AD within 3 days from the date of this order, returnable after 3 weeks in interlocutor. Third, Mr. N. Patiri, learned counsel for the petitioner, also Mr. P. Bhattacharya, learned additional public prosecutor. This interlocutory application has been preferred under section 397 of the Code of Criminal Procedure, 1973, by the petitioner Prabhas Patwari, praying for suspension of the sentence imposed on the present petitioner by the order dated 18/2/2020 passed by the London Judicial Magistrate First Class in CR case number 4200/2013, whereby the present petitioner has been convicted under section 138 of the NI Act 1881 and was sentenced to undergo simple imprisonment for 6 months and to pay a compensation for rupees 13 lakhs and with default stipulation. And counsel for the petitioner has submitted that the appeal preferred against the judgment passed by the London Trial Court was dismissed for default by the London First Appellate Court by order dated 21/11/2023, passed in criminal appeal number 43/2020. The present petitioner has preferred a criminal revision against the said order, which is registered as criminal revision petition number 11/2024. Learned counsel for the petitioners has also submitted that the petitioner is presently on bail granted by the learned lower court. Issue notice to the respondents. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to the respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from the date of this order, returnable after 3 weeks. Since the petitioner has been convicted, only petitioner has been sentenced to undergo imprisonment only for a limited duration of 6 months, and he is already on bail granted by lower court. The operation of sentence imposed on the petitioner by the impugned judgment shall remain suspended till the returnable date, list accordingly.
My lord, only humble submission, my lords, if it can be disposed of as early as possible, my lords, the mandate is clear, my lord.
No, let the notice be served.
My lord.
Make legal option. My lord, this is a criminal revision petition against the judgment and order passed by the learned session judge Hailakandi in criminal appeal number 7 of 2019, upholding the, my lord, punishment inflicted by the learned trial court, my lord. 1 year, my lord, so far petitioner number 1, 2, and 3 is concerned. Then, my lord, so far petition number 4 is concerned, my lord, he is, my lord, the inflicted punishment of 2 years, my lord, under section 325, my lord.
What is the ground for
My lord, ground is that, my
first
lord.
appellate court upheld your conviction?
Yes, my lord.
What is the error?
Error, my lord, here, my lord, all the prosecution witnesses are contradictory, my lord, and FIR was also
You are in jail or outside?
outside, my lord.
Third, Mr. A.M. Borguia, learned counsel for the petitioner. This application under section 397/401 of the Code of Criminal Procedure, 1973, has been preferred by the petitioners, namely 1, 2, 3, 4, impugning the judgment and order dated 4/12/2023 passed by learned additional sessions judge Hailakandi, whereby the criminal appeal number 7/2019 referred by the present petitioners was dismissed, and the judgment and order dated 2/6/2018 passed by learned judicial magistrate first class Hailakandi in GR case number 1321/2011 was upheld by the said judgment of the learned trial court. The petitioner number 1, 2, and 3 were convicted under section under section 147 of the Indian Penal Code and were sentenced to undergo simple imprisonment for 1 year. They were also convicted under section 341 of the Indian Penal Code and were convicted to undergo simple imprisonment for 1 month. Whereas the petitioner number 4 was convicted under section 147 of the Indian Penal Code and was sentenced to undergo a simple imprisonment for 1 year. He was also convicted under section 148 and was sentenced to undergo simple imprisonment for 1 year. He was also convicted under section 323 of the Indian Penal Code and was sentenced to undergo simple imprisonment for 1 year, and was also convicted under section 325 of the Indian Penal Code and was convicted to undergo simple imprisonment for 2 years. All the sentences were directed to run concurrently. Issue notice to the respondents. Now, since learned additional public prosecutor has appeared for the sole respondent, no formal notice need to be issued to the respondent. Let this matter be listed. Call for the Agor Abhishek in all earlier cases. Call for the NCR in all revisions. Call for the NCR. Fixing and let this matter be listed after 3 weeks. In interlocutory application, this interlocutory application has been preferred by the petitioners 1, 2, 3, and 4 under section 1, 1, 2, 3, and 4. Under section 397 of the Code of Criminal Procedure, 1973. Praying for suspending the sentence imposed on the petitioners by the judgment and order dated 2/6/2018 passed by learned Judicial Magistrate First Class Hailakandi in GR case number 1321/2011, which has been upheld by the judgment and order dated 4/12/2023 passed by learned additional session judge Hailakandi in criminal appeal number 7/2019. The petitioners have impugned the aforesaid judgments by preferring a criminal revision petition, which is registered as criminal revision petition number 12/2024. Learned counsel for the petitioners has submitted that the petitioners are presently on bail granted by the lower court. and has prayed for suspending the sentence. Considering the fact that the petitioners are sentenced for maximum, petitioner number 1, 2, and 3 are sentenced to a limited period of 1 year, limited sentence of 1 year only. Sentence limited to a limited duration of 1 year only, whereas petitioner number 4 has been sentenced to undergo simple imprisonment for limited duration of 2 years only, and all of them are presently on bail. Therefore, during the pendency of the criminal revision petition number 12 of 2024, the operation of sentence imposed on the present petitioners by the impugned judgment is hereby stayed.
Yes.
This interlocutory application is accordingly disposed of.
Diploma.
Item 12.
May I please lordship? Lordship, this criminal petition is filed for Quashing PRC number 128 of 2023 arising
It
out.
has been laid.
Yes, my lordship.
What is the ground
Pardon?
for quashing?
I have no involvement in this matter. Because
That may not be a ground for interfering
Yes, ma'am.
under 482.
Otherwise, in my petition, my lord, contents of the FIR is not available. And my lord, contents of the search sheet is also, my lord, not annexed in my petition.
If you are on facts, 482 does not lie. Where is the ground for quashing?
my lord, page 4, my lord, last paragraph.
Yes, make your submissions.
The allegation is, my lord, that I have debarred the complainant from allotting a house under Pradhan Mantri Awas Yojana, which was allotted to the husband of the informant, my lord. And my lord, in this regard, a resolution was taken as he was not available and has never appeared before the Panchayat office, my lord, to claim his house. And in this regard, my lord, a resolution was taken that is in page.
No, you are on facts.
Yes.
Facts you can plead before trial court. What should I do? Dismiss it.
Well, I
Yes,
will given opportunity so that on the next day,
you come prepared
if
on prayer of learned counsel for the petitioner. Let this matter be listed. When do you want it? After vacation.
My lord, a new copy may be kindly sub, because in my
Petitioner
copy,
is also
copy-
directed to furnish a copy of the criminal petition, fresh copy of the criminal petition
Yes, ma'am.
with all annexures
Yes.
to the learned additional public.
Item 13.
Please, Your Lordship. Here, my lord, we was assailing an order by which standing arrest warrant was issued against me following a proceeding under section 82 and 83 of the CRPC. And also, my lord, we're assailing the very initiation of process for proclamation and attachment. Now, this respondent, my lord, he filed a complaint case for my prosecution under section 138 NI Act. Checked amount is of 2 lakhs. Initially, my lord, summons was issued. Returned with the report that I was not found in the address. Then, my lord, the bailable warrant was issued, followed by non-bailable warrant. Then, my lord, by page 19 order, Lord, you may kindly turn to page 19. The trial court was pleased to issue process for proclamation. Complainant is absent, which said by so and so. Accused is absent. Warrant of arrest against him has been returned with the report that he is not traceable at the given address. Learned counsel for the complainant side has submitted that the accused is still available in the given address. It can be presumed that he is intentionally concealing himself for avoiding the process of the court. Hence, to compel his appearance, issue proclamation.
On the submission of learned counsel. On the
Yes.
submission of learned
Yes, madam.
counsel.
So by this order, the trial court invoked section 82. Now kindly see section 82(1), when it can be invoked.
Yes.
When the trial court has reason to believe that a person against whom the warrant issued, he is absconded or he is concealing himself, so that this warrant cannot be executed. So this reason to believe, my lord, has not been, my lord, described in CRPC, but it is in section 28 of the IPC, it is defined.
20?
28 of the IPC,
Yes.
the reason to believe, this expression. It means sufficient cause to believe. Existence of a fact and not otherwise. Section 26. So this reason to believe or sufficient cause to believe implies existence of some materials on record, which will provide the trial court the reason
No,
to believe.
section 26.
My lord, IPC.
26 IPC. Okay.
So my submission is, now this reason to believe implies existence of some materials on record. Now, logically, at that state, my lord, only material could be the report of the process server. Meaning thereby, there must be a report of the process server indicating that I have absconded or I am concealing myself in order to avoid execution of this warrant. There is no such report. Absolutely. The report is I was not traceable in the address. The complainant side make a statement, no, I was available in the address. And based on that, simply issued the process for proclamation. And kindly also appreciate what 82(1) says, that he must have reason to believe that I am avoiding this warrant because so that it cannot be executed, meaning thereby I must have the reason. I must be aware that this warrant has been issued against me. And that is why I am concealing myself, so that this warrant cannot be executed. So accused must be attributed with the knowledge of issuance of this arrest warrant. And also that my concealment is intentional just to frustrate this execution of this warrant. There is no such report. The order did not indicate that. That is must. It's a sine qua non for issuing a written proclamation. So this order on the face of it is, my lord, improper, invalid. That is my first submission, madam. Secondly, by page 24, but you may kindly come to page 24. The learned trial court simultaneously issued proclamation and attachment order. Lordship will find
This was an earlier, order,
15/12/2021 order.
later order.
Later on, subsequently. Issue proclamation and attachment against the accused. So in the learned trial court invoked section 83 for the first time. Now, under 83, trial court has the power to simultaneously issue attachment order with proclamation. But it has a rider. Before that, he must be satisfied on the basis of an affidavit. Can you see 83? Proviso.
What otherwise?
Ma'am. On the basis of an affidavit
Or otherwise?
or otherwise. Here is no affidavit.
But otherwise?
There must be some reason, my lord.
Okay.
Affidavit or otherwise to believe
Some materials
some materials
must be there.
so that I'm going to dispose my property. And therefore, this simultaneous order of attachment and proclamation. There is nothing. The order did not indicate that. Now kindly come to next page, my lord. Page 25. 22/6/2022 order, my lord. Kindly see, I'm reading from the third para, my lord. Sin warrant of arrest along with proclamation and attachment issued against the accused person, return with the report that the attachment could not be executed as no movable property found in the name of the accused, and the proclamation was duly hanged as per law. As such, issue standing warrant of arrest against the accused person. Let the case be filed until further order. So proceeded on the premise that I am a proclaimed person. And because of that, a standing warrant of arrest was issued and a case stood filed. Now, kindly see the report at page 28, my lord. Based on that report, this order was passed.
Yes.
Can you see page 28 report of the process server? May read.
Yes.
I beg to report that I have made proclamation against a proclaimed person so and so on the strength of the honorable court order by public road to announce and fixed a copy in a conspicuous place of the locality in presence of the following witness signature as defined under section 82 CRPC. Well, for factum of a valid proclamation, this clause 1 and 2 has to be complied with, subsection 1 and 2
Of 80.
of section 82.
Okay.
82 says proclamation must give a clear 30-day notice to accused. Here, Lordship will find in there is a signature of officer in charge dated 22/6.
Where, in which page?
It is 28.
28.
28.
Yes.
Officer in charge, so and so. So it was put up on 22/6. This proclamation was made on 22nd June. On the very same day that this matter was posted.
No, I am not getting you. This,
Well, this 82 one can be seen.
it gives that it
30 days notice.
To
It
the-
says the written proclamation should be made specifying a particular place and a particular date to appear to the accused, not less than 30 days from the date of publication of the proclamation.
Yes.
So accused must have 30 days notice to appear from the date of publication of the proclamation. Now, page 28 is the publication.
No, page 28 is the report only.
Reports showing publication.
Okay.
Showing publication. Publication is important. And what date it was published? It was published on 22nd June.
So 30 days notice must have been given in the
Exactly.
notice.
And kindly see 82.3. Order must indicate the date when this proclamation was published. Subsection 3. A statement in writing by the court which issued the proclamation.
No, you have not annexed a copy of proclamation so that we can say,
No, this is the proclamation order. Kindly see 26, page 26.
oh, yes,
On this is the report.
on or before, he was directed to appear on or before 26.
Yes,
22/6.
yes, that is the date fixed.
And the,
This proclamation was published on the same very date,
okay.
22nd 6.
So no
No,
time was given.
not only that, this order 22/6, my lord, must indicate the date when this proclamation was published. That is the mandate of subsection 3. Can you see subsection 3? A statement in writing by the court which issued the proclamation that this proclamation was published on a specified date following the mandate of section 82 shall be the conclusive evidence that the requirement of 82 has been followed. Where is the date? Neither in the order passed by the trial court nor in this report.
This proclamation was issued on 6th of April.
6th of April.
So whether it was hanged,
This is the report. We'll go by the report. Page 28 report.
yes,
Now, clause A, B, C of subsection 2(1) has to be complied with. Now, A, B, C says
what 28 report says?
that it was hanged, it was announced publicly, it was read publicly, and it was hanged in a conspicuous place of the locality. C was not followed.
Okay,
Kindly see C, clause 1C.
Okay.
It should be also affixed at the conspicuous place of the courtroom. Courthouse, that was not followed. And A, B, C are not disjunctive. All must be followed. These are conjunctive, is requirement of
No.
2(1).
now what is your submission?
But this is apparently wrong, my lord. Right now, my prayer is let notice go. And in the meantime, this operation of the standing warrant should be kept in abeyance.
You appear before the trial court.
No problem, no difficulty. In that case, my prayer will be, my lord, Lordship may kindly substitute this non-bailable warrant to a bailable warrant. Fix a date, I will appear, and the matter will proceed, my lord. No difficulty. Because apparently, my lord, on the face of it, it is wrong.
Heard Mr. N. Nath, learned counsel for the petitioner. Yes, Mr. Bhatnagar. Let-
State is not a party, madam, in this case.
It's a
This
complaint
is
case,
a,
madam. Complaint case, madam. No required.
this is a NI Act case.
Madam.
Notice has to be.
Yes.
Heard Mr. N. Nath, learned counsel for the petitioner. This application under section 482 of the Code of Criminal Procedure 1973 has been preferred by the petitioner, namely Shri Nilotpal Chaudhary, praying for quashing the orders dated 22/6/2022, 8/3/2019 and 15/12/2021, passed by the Court of London. Which court?
Just a minute.
Which is the
JMFC 4, my lord.
Court of London, Judicial Magistrate First Class, number 4, Ramrup Metro,
Metro.
in complaint case number 1432/2018, whereby initially order for proclaiming the petitioner as absconder and orders for attachment of his property were issued, and thereafter a standing non-bailable warrant of arrest was issued against the present petitioner. Learned counsel for the petitioner has submitted that the CR case number 1432/2018 has been preferred by the respondent against the petitioner under section 138 of the Negotiable Instrument Act, about which the present petitioner was not aware. It is submitted by learned counsel for the petitioner that initially summons were issued to the present petitioners, however, initially summons were issued,
Well,
then summons were served. No.
no.
However, same were not served, and thereafter warrant of arrest were issued against the present petitioner. It is submitted by learned counsel for the petitioner that by order dated 8/3/2019, which is also impugned in this revision, in this criminal petition, the warrant of arrest issued against the present petitioner was returned to the court, was returned to the court with a report that the present petitioner is not traceable in the address given in the warrant. However, the learned trial court, only on the basis of the submission made by learned counsel for the respondent / complainant of the case, that the present petitioner is still available in the given address, presume that the present petitioner is concealing himself and is avoiding the process of court, and issued proclamation as well as fresh warrant of arrest. Learned counsel for the petitioner has submitted that the mandate of section 482 of the Code of Criminal Procedure has not been followed by the learned trial court while issuing proclamation order against the present petitioner. As before issuing such order, court must have a reason to believe that any person against whom a warrant has been issued by it has been absconding or concealing himself so that such warrant cannot be executed. However, in the instant case, there was no material on record to arrive at such a satisfaction by the learned trial court. Learned counsel for the petitioner has also submitted that merely on the basis of submissions made by the counsel for the complainant, orders for proclamation were issued against the present petitioner when there was no sufficient cause, there was no material before the court to arrive at sufficient cause for believing that the present petitioner is evading, has absconded or concealing his arrest, concealing himself to evade from the processes of the court. Learned counsel for the petitioner has also submitted that even while the attachment order were issued, attachment of property, orders were issued for attachment of property, the mandate of section 83 of CRPC was not followed in this case. It appears from record that in the proclamation order issued by the court by order dated 6th April 2022, the date for appearance was fixed on 22/6/2022, whereas from the report of the process server, it is not clear that on which date that the said proclamation was published, so as to verify whether the 30-date notice was given to the present petitioner or not. Stop. Issue notice to the respondent. Learned. Issue notice to the respondent. The petitioner shall take steps for issuance of notice to the respondent by registered post with AD within 3 days from the date of this order, returnable after 3 weeks. In the meanwhile, as apparently it appears from record that there has been a violation of section 82 as well as section 83 of the Code of Criminal Procedure while issuing the order of proclamation and attachment against the present petitioner. The operation of the non-bailable warrant of arrest issued against the present petitioner, as well as the proclamation and attachment order issued against the present petitioner, shall remain in abeyance. The petitioner is directed to appear before the learned trial court within
10 days.
within 15 days from the date of this order, shall be kept in abeyance for next 1 month. The petitioner is directed to appear before learned trial court from within a period of 15 days from the date of this order. The petitioner may make prayer for appropriate relief before learned trial court on his appearance before the said court. Regarding bail, you have to pray. Let this matter be listed again after 3 weeks.
This order was kept abeyance for
1 week.
1 week,
1 month.
1 month.
You have been given 15 days time to appear.
I will.
The warrant shall remain in abeyance for 1 month.
Right.
And then for leads.
May I please, sir? Worship, I'm appearing on behalf of Mr. A.M. Shoikia. Worship, at present he is out of station due to his mother's illness. Lordship, kindly pass the matter for the,
on the day.
yes, Lordship.
Heard Mr. What is your name?
Lordship,
what-
it's J. Firdos,
J.
Firdos.
J. Firdaus, learned counsel
yes.
for the petitioner, who prays for an adjournment on the ground that the conducting counsel, Mr. M. Saikia, is out of station. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after a week.
Must,
Item 15.
May please, your Lordship. This petition under section 482, Lordship. In the CR case, Lordship, CR case is registered under section 498, 353 and 34, Lordship of IPC. On the ground that, Lordship, petition is case 12, Lordship, type code, vernacular code, page
What is the ground?
16. Ground that, Lordship, after marriage in the year 2018, complainant only 5 to 6 months resides in the accused petitioner's house, Lordship. Thereafter, she left the house of the matrimonial house, Lordship, with her husband, Lordship. And they have started their conjugal life in her parent house, Lordship. The husband is not before your Lordship, they are the family members, Lordship. They are no way connected with the present complaint case, Lordship.
No, but on facts, you can raise this plea before the trial court.
Yes, Lordship, but Lordship, this is, there is no probability on the part of the present petitioner, Lordship, that they will found guilty after.
Why?
Lordship, the cause of action is arises in her in her parental house.
No, on
Lordship.
facts, it is difficult.
Yes. If you kindly see here, page 13, Lordship. CR petition, Lordship.
Where is the ground?
Ground, Lordship, is page paragraph 4, Lordship, I have stated, Lordship. She is continuously after
You will
marriage,
not get
Lordship.
any relief. 482.
Lordship. Only initially 5 to 6 months she continues her conjugal life in her matrimonial house, Lordship. Thereafter, she left the house, Lordship. And they
Yes,
have started their
Mr.
conjugal life in her parental house, Lordship.
Buttercup.
Yes, this notice may be issued. And Lordship, allegation.
Heard Mr. A.B.T. Hawk, learned counsel for the petitioner. Also heard Mr. P. Buttercup, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioners number 1, 2, 3, and 4, praying for quashing the CR case number 1206/2023, filed by the respondent number 2, which is pending in the Court of Learned Chief Judicial Magistrate Hailakandi. Issue notice to the respondents and call for the scanned copy of the case in court of CR case number 1206/2023. As learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice to respondent number 2 by registered post within 3 days from the date of this order, returnable after 3 weeks.
Husband is not before your Lordship. In the interim, Lordship, against the present petitioner, Lordship, no be stayed for some time.
This is not a case for him.
Otherwise, my lord, this petition is liable to be
This is
dismissed.
a case whether to see whether this petition is maintainable or not.
Yes, sir.
Let this matter be listed after 4 weeks.
Item 16.
May I please, your Lordship? Lordship, this present petition is referred by this petitioner for quashing the proceeding of CR case pending before the learned court of Sizem Bozali. In this case, Lordship, After perusal of the case record and after recording the statement under section 200 of CRPC of the complainant as well as the other two witnesses, court has taken cognizance of the offences under section 494, 294, 506 and 120B. Here in this case, Lordship, 494 does not affect this present petitioner, she being the second wife of the opposite party's husband, Lordship. It is alleged that she is the wife of the second wife of the opposite party, Lordship. And from the other section, in respect to the other sections, Lordship, there is no any whisper in the complaint petition as well as in the statement of witnesses recorded under 200 CRPC, Lordship. There is not a single whisper that she has committed the offences 294, 506 and 120B, Lordship. Therefore, Lordship, it is prayed that this proceeding may be
Let us see the complaint petition.
Lordship. The vernacular is page number 19, Lordship.
Under what provision the cognizance has been taken?
Cognizance has been taken under section
494.
494, 294, 506 and 120B.
120B, who else is there?
120B, it is alleged that opposite party's husband Kamal Kumar Kulta and Kulta, the brother of husband of the opposite party, Lordship. It is stated that they have threatened her,
They are also the accused.
Lordship. They are also accused. She has filed this complaint against three persons. His wife Kamal Kumar Kolita, Plavita Deka, that is present petitioner, and Kulta.
But present petitioner is
Plavita Deka.
Labita or Linamoni.
Linamoni is the first wife. It is alleged that her husband Kamal Kulta has married Plavita Deka, this present petitioner, during her lifetime. So 495, if it is attracted, it will be attracted towards Kamal Kumar Kulta, Lordship, not against this present petitioner, Lordship.
Read the petition.
Lordship.
Where are the allegations?
Lordship.
294 allegations. Your submission is that there is nothing mentioned regarding offense under section 297,
294, yes, Lordship.
294.
Lordship, in page number 22, in para 7 of our complaint petition, she states, অবকাশ উপায়ন হৈ ফৰিয়াদী আসামীৰ বিৰুদ্ধে খুৰাকী বিচাৰি বজালী মহকুমা ন্যায়াধীশ আদালতৰ 1 নং আসামীৰ পৰা মাহিলী খুৰাকী আদায় কৰি দিয়াৰ প্ৰাৰ্থনা এটি খুৰাকীৰ গোচৰটোৰে যাৰ কেছ নম্বৰ 56/2014 উক্ত গোচৰত 1 নং আসামী প্ৰথম অৱস্থাত হাজিৰ হৈ অন্তৰ্বৰ্তীকালীন মাহিলী খুৰাকী আদায় দিয়াৰ পাছত উক্ত গোচৰত হাজিৰ নহয় আজিলৈ কোনো খুৰাকী আদায় নিদিয়াকৈ আছে উক্ত খুৰাকীৰ গোচৰত ফৰিয়াদী 1 নং আসামী মাহিলী খুৰাকী সমুদায় আদায় নিদিয়াৰ বাবে মহামান্য আদালতে আসামী একৰ বিৰুদ্ধে জামিনবিহীন গ্ৰেপ্তাৰ পৰোৱানা জাৰি কৰে যাৰ বাবে যোৱা 2022 চনৰ ছেপ্টেম্বৰ অক্টোবৰ মাহত আৰক্ষীয়ে তেওঁক গ্ৰেপ্তাৰ কৰে মহামান্য আদালতত হাজিৰ কৰাত আসামী 1 নং আদালতে এমাহৰ বাবে জেললৈ প্ৰেৰণ কৰে আৰু তেওঁ হাজতি খাটি আহিবলৈ বাধ্য কৰে এনেদৰে ফৰিয়াদী 1 নং আসামীৰ পৰা শাৰীৰিক মানসিক আৰু অৰ্থনৈতিক শাস্তিৰ সন্মুখীন নানান অভাৱ অভিযোগৰ মাজেৰে জীৱন কটাই আহিছে এইদৰে থাকি 1 নং আসামী ফৰিয়াদী নানান অত্যাচাৰ আহাৰ প্ৰকৃত ৰহস্য প্ৰমখেদি জানিবলৈ সক্ষম যে 1 নং আসামীয়ে 2 নং আসামীৰ লগতে গোপন অভিকাৰত লিপ্ত হৈ ইতিমধ্যে 2 নং আসামীক 1 নং আসামীয়ে তেওঁৰ প্ৰথম পত্নী অৰ্থাৎ ফৰিয়াদী বৰ্তমানৰ মনে মনে 2 নং আসামীৰ চাকৰিৰ লোভত অবৈধভাৱে গোপনে আজিৰ পৰা 8-9 বছৰ আগত দ্বিতীয় বিবাহ কৰায় This present petitioner is a government employee, Lordship. It is alleged that her husband had married her in the greed of that job, Lordship. Here in this case, Lordship, this present petitioner had nothing to do. She had no knowledge that her husband had married earlier, Lordship.
Okay. 294 is not against the present petitioner.
No, Lordship.
Who is accused number 3?
Pulen Kulita, it is the brother of the accused number 1. Accused number 1 is the husband of the opposite party. And accused number 3 is the brother of that accused person.
And in statements,
Statement, Lordship, page number 29. Type copy is in 28, Lordship. Okay. I have filed this case against Kamal Kolita, his brother Pulen Kolita, and Kamal's second wife Labita Daga. On 3/4/2010, I got married to Kamal Kolita socially, and subsequent to marriage, he took me to his quarter in 9 Mile, Guwahati. There he tortured me physically and mentally. He didn't allow my parents to meet me, nor did he allow me to contact my parents. Accused Kamal Kolita beat me in drunkard condition. On 1/8, I, finding no alternatives, came to my house. Later, I came to know that my husband had married another woman. I have filed another case for maintenance against my husband where he didn't pay any maintenance. So warrant of arrest was issued against him. Accused Pulen Kulta threatened to beat me and kill my parents. Yes.
Kulen is the brother.
Pulen is the brother of Kamal Kulta.
Okay. Okay. Any other witness? CW2.
In 2 and 3 also, there is nothing against this present petition or logic. In page number 31.
Heard Mr. Yes,
Well, state is not a party in this.
heard Mr.
KK Henry Lordship.
A.K. Hendrik, learned counsel for the petitioner. This application under section 482 of the Code of Criminal Procedure 1973 has been filed by the petitioner Srimati Labita Deka for quashing the CR case number 446/2023 filed by the respondent Srimati Linamani Kalita, on the basis of which the Court of London SDJM M. Bojali, Patshala took cognizance of offence under section 494/294/506 of the Indian Penal Code. What is the state? Process have been issued.
Yes, Lordship.
Where is the order?
It is in page number 37, type copy.
Whereby the cognizance of offence under section 494/294/506/120B IPC has been taken and processes were issued against the present petitioner and other accused persons. Learned counsel for the petitioner has submitted that the respondent has filed a complaint case which was registered as CR case number 46/23, wherein the present petitioners was named as an accused number 2, along with other 2 accused, namely Kamal Kumar Kalita, who is the husband of the present petitioner, as well as Kulen Kalita, who is the brother-in-law of the present petitioner. It is submitted by learned counsel for the petitioner that the respondent in her complaint petition filed before the learned trial court has alleged that there is the accused number 1 named in the complaint petition has married the present petitioner during the subsistence of his marriage with the complainant Srimati Linamani Kalita. Learned counsel for the petitioner has submitted that the offence, as the petitioner was not aware of any marriage of her husband with any other woman, and as there is no allegation of second marriage, by her in the complaint petition, the offense under section 494 of the Indian Penal Code is not attracted against the present petitioner. It is also submitted by learned counsel for the petitioner that no allegation under section 294/506 has been made in the complaint petition against the present petitioner, as specific allegations under said sections are made only against the co-accused, namely Kamal Kumar Kalita and Kulen Kalita, and there is no whisper about any allegation under section 294/506 of the Indian Penal Code against the present petitioner. Therefore, learned counsel for the petitioner submits that the learned trial court erred in issuing processes against the present petitioner, though there were materials against the other two co-accused persons. Stop. Issue notice to the respondent. The petitioner shall take steps for issuance of notice to the respondent by a registered post with ID within 3 days from the date of this order, returnable after 3 weeks. In the meanwhile, as it apparently appears from the materials on record that no offense under section 494 has been made out against the present petitioner, and there is no material on record, including the complaint petition, as well as the deposition of witnesses recorded under section 202 CRPC against the present petitioner under section 294 and 506 of the Indian Penal Code. The further proceeding of the CR case number 46/2023, qua the present petitioner is stayed until returnable date. Let this case be listed accordingly.
Deeply obliged, Lordship.
Well, please, Lordship. Against the order, Lordship, rejecting my Jimma petition, Lordship. Jimma of a vehicle, Lordship, just seized by the police. And at this stage, Lordship, I will pray kindly for call for a report, Lordship.
Heard Mr. S. Munir. Report or CD would be required.
No, my lord, only report from the IO because, my lord, in view of the my lord, division judgment of the division bench, learned trial court has rejected the prayer of the my lord, Jimma of the petitioner. So now at this stage only IO has to send a report whether the vehicle is required for further
Heard Mr.
investigation.
S. Munir, learned counsel for the petitioner. Also heard Mr. P. Bhattakumar, an additional public prosecutor. This application under section 482 of the Code of Criminal Procedure number 1973 has been filed by the petitioner Luis Ahmed, impugning the order dated 9/10/2023, passed in which case?
Page 43, Lordship. Page
Ca-
43.
Case number?
Byra Charlie, 277, Lordship.
Impugning the order dated 9/10/2023, passed in Bahata Sarali PS case number 277/2023. Within bracket, Jimma case number 592/23. Whereby the prayer of the present petitioner for grant of Jimma of the seized vehicle was rejected by the learned trial court. Call for it.
Yes, yes.
I'm taking break for one
Yes, yes, yes.
report from the investigating officer as to whether the seized vehicle is further required for the purpose of investigation or not. And the report be called for on
On 29/1.
29/1.
Much obliged, Your Honor. Much obliged, much obliged.
Item 18.
In this case, the application number 482, the informant's husband, he was pillion riding with the petitioner and he fell down and the case was registered under 279 and 304A. And thereafter, the charge sheet was filed and notice has been issued. But the informant, that is the respondent number 2, she has filed and she has entered into a settlement with the petitioner, my lord. And it has been annexed as annexure 6 at base 30, my lord. Though the case is fixed on May, my lord, I at this stage pray, my lord, that notice may go to the respondent number 2 and the case diary and the CD may be called for, my lord.
304A is not non-compliant.
There's a covered judgment, my lord. My lord,
Okay, we are issuing notice.
yes, ma'am.
Heard Mr. S. Count, learned counsel for the petitioner. This application under section 482 of the Code of Criminal Procedure, 1973 has been filed. Praying for washing of has been filed by the petitioner, namely Deep Gupta, praying for quashing of the FI of the CR case number. Praying for quashing of the PRC case number 1796 of 2018. Pending in the Court of London, Additional Chief Judicial Magistrate, Kamrup Metro. Issue notice to the respondents and call for the scanned copy of the case record of PRC case number 1796/2018. The petitioner shall take steps for issuance of notice on the respondent by registered post with ID within 3 days from the date of this order, returnable after 3 weeks. Let this case be listed accordingly.
Can the case diary will also be called, my lord?
Let also the case diary be called for case diary of
The Jalukbari PS case, my lord. Jalukbari PS case number 953 of 2017.
Jalukbari PS case number 953 of 2017
17.
be also called for. Let this case be listed again on after 3 weeks.
I prayed for stay, my lord, of the further proceedings. my lord.
No, your next date is fixed on May.
May, then it's okay. my lord.
So it will be
A date may be fixed, my lord.
after 3 weeks, let a date be fixed. 2nd February.
No problem.
Item 19.
May please your lordship. The FI is in page 12. This case is arise person to an altercation, simple altercation. But as the informant happened to be a constable of the police station where the FI was filed, they are trying to harass the present petitioner, your lordship.
Where is the FIR?
FI is in page 12, Your Lordship. Vernacular is in page 14. May I read you?
Yes.
It is to respectfully state you that I am a police personnel of Assam Police posted in Bosista Police Station. I and my friend Pulin Deka, after completion of my duty, went to Suresh Dhaba situated near Bosista Balughat for dinner at about 10:30 p.m. As there were many people came for dinner in the dhaba, we came out of the dhaba and stand outside after placing our order for roti. In the meantime, I felt an urge for urination and therefore went a darker place near the dhaba for urination. And while discharging urine, three boys came near to me and started to abuse me with filthy language. Although I behaved in a polite way, they still started to beat me and pull in and hit my head with sharp weapon, causing severe injury to my head and also threaten us with dire consequences. They also snatched away and broke.
326 is there.
Yes.
Case diary would be required.
Yes, Your Lordship, kindly come to the page, Your Lordship, three, that is Annexer 1, Your Lordship. Annexer 1 is in page 11, Your Lordship. This is the license copy of a foreign liquor shop.
Yes.
This is the license copy of a foreign liquor shop of the present petitioner, which is located in the same place, Your Lordship. And what happened, that is in page 5, Your Lordship, I have categorically mentioned that it is true that they went to the dhaba and go for urination. But the darker place who he referred happens to be the door of this shop of the petitioner, Your Lordship. So he urinated in the shop of the petitioner and petitioner came and told him not to do so. That's why he got angry and slapped the petitioner, Your Lordship. And that,
But the allegation is of 326.
but because they are the police personnel, they exaggerated,
Case diary would be.
but some kind of protection may be given. He will go and cooperate if any.
No, not now, after.
But because they are police personnel, they are already started demanding money and harassing the family person, stating that they will get rejected the license of the shop of the petitioner also, Your Lordship. So at least interim protection may be given. He will go and cooperate with the police investigating officer, Your Lordship.
Now, what is your submission regarding the assault?
That is
Grievous injury.
exaggerated version of the informant, Your Lordship. Simple altercation, nearby persons were there, because Your Lordship will appreciate that nobody will come and started abusing and beating one person who is urinating without any reason, without any spark. There may not be a smoke, Your Lordship. So it is true that he is creating that situation, Your Lordship.
326. When
Moreover, my
can
lord,
you-
gold chain is also snatched.
They are exaggerated version only to
18
book the person.
we are fixing a short date.
18 lords.
But although they will try to harass him because they are the police
No,
person,
but you
there is a
don't have
chance
a-
of abusing power. You know, so some at least interim protection, maybe he will go and cooperate with the investigating officer. You know,
After perusing the case diary. We are
18.
fixing a short date, 18.
Lords.
Heard Mr. U. Saikia, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Considering these allegations leveled in the FIR, perusal of the case diary would be necessary for consideration of the instant bail, anticipatory bail application, hence call for the case diary. Fixing 18-1 for case diary.
Item 20.
Pressure হলে নামি যাব। Oh, Gaurav, yes.
May I please, Your Lordship? Lordship, 438 bail application, Your Lordship. FIR is at page 9, type copy, textured type copy, Your Lordship. The vernacular is at page 13, Your Lordship. Lordship, the FIR was lodged on 6/12/2023 by one Azmina Begum, your Lordship, of Tetilia village under Nogao district, your Lordship. Her allegation was that, may I go to the FIR, your Lordship? Lordship, with due respect, I beg to state that about 5 months back, I borrowed an amount of rupees 5,000 from the accused. At the time of borrowing the said money, I assured to return the money only after 2 months. After about 1 week of borrowing the money, he called me over phone and asked to return him the money and verbally threatened and abused me. On the next day, he again called me over phone and asked me to return the money and threatened that he would inform the villagers and defame me. Again, after a week, he again called me and asked to return the money and or send him my obscene video. I did not inform my husband and my family about borrowing the money and asked the accused person not to inform about the same to them. And taking the opportunity, he threatened to defame me and inform my husband, and I got scared. Again, one day, when he called me and asked to return the money or send him an obscene video, I mistakenly sent him an obscene photo. After about a week of this incident, having come to know that I was alone in my house, he entered into my house and forcefully committed rape. While committing rape, he recorded the video and sent it to his friend and defamed me and made it impossible to live within the society. Thereafter, the case was registered, your Lordship. This is a pure case of your Lordship. See, it is true that she took money and she had to return the money. Just to avoid from returning the money, she gave this matter case, your Lordship.
Case diary would be required.
Somehow he may be protected, your Lordship. The Lordship, the incident that occurred nearly 6 months back, not even 6 months, the way she stated regarding the rape, no date was mentioned when the rape was committed, how or anything was not mentioned, your Lordship. She only stated that 1 week later, 1 week later, 1 week later, this and this happened, your Lordship. The way the FIR is stated, your Lordship, we can come to the conclusion that this happened way before she lodged the FIR. She somehow told that 5 months before she took the money. Lordship, this is a clear motive of defaming the petitioner and just differing from the obligation of paying the money. That's all, your Lordship. Somehow her husband came to know about the money situation, and to avoid from all this, she just concocted a story and then lost this FIR, your Lordship. I may be protected, your Lordship, in this matter.
Yes, Mr. Das.
Lordship, circulation is also there as per the FIR, Lordship. The recorded video has been circulated. Moreover, allegations are also serious.
And this circulation is, your Lordship, this is also false, your Lordship. There is no such circulation, your Lordship.
Then
When it was circulated, it was also not even mentioned, your Lordship.
19, Lordship.
we have to peruse the case diary.
I may be protected, your Lordship.
Not now. I've heard Mr. A. Ganguly,
D. Chetri, your Lordship.
D. Chetri, learned counsel for the. So, Mr. Chetri, that's the- Nature of allegations level in the FIR. Perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary. Fixing
22.
22 for case diary.
Obliged, your Lordship.
Item 21.
May I please your Lordship, matter may be taken at 2 PM, Lordship. My senior election court number 14, Lordship. Opposed.
Item 22.
May it please your Lordship. Lordship, this is an 438 application. The matter is such it, your Lordship. The petitioner
Charge
is,
sheet hai?
yes, your Lordship. I have approached your Lordship, court below, your Lordship. This is, I am implicated under section 366, your Lordship. Your Lordship will find the FIR from page 12, the translated copy starts, your Lordship. But your Lordship,
366.
366. Now I will take your Lordship to the 164 statement of victim, your Lordship, alleged victim.
No, but why anticipatory bail?
Your Lordship, 366.
Oh, your notices have been issued to you.
No, your Lordship, nothing has been issued to me, your Lordship. So
It
in
is
the
a-
search sheet, I
It
have
is a
been,
charge sheet case.
yes, your Lordship, in the search
Where
sheet,
is the apprehension of arrest?
your Lordship, in the search sheet, I was shown as an absconder, your Lordship.
Still, the court will issue summons to you.
Yes, your Lordship, but I,
Courts have not yet issued summons.
no, your Lordship.
Then it is premature.
No, your Lordship, Actually, the court proceeding is going on, your lordship. And you also have to approach the trial court for a bail application, your lordship. And the trial court and the court below has rejected my application, your lordship. That I have annexed to your lordship. Against that order, I have come, your lordship.
Rejected the application
Yes, your lordship. For bail application, your lordship.
and not taken you in custody.
No. No, your lordship. I have not appeared, your lordship. My learned counsel has appeared here. Court below, your lordship.
Then without appearing, without being in custody, how have you moved bail application
Your lordship,
under 439?
this is a 438 application. Your lordship,
Where is the rejection order?
your lordship will find on page 36. May I read your lordship. Page 36.
That is a 438 application.
Yes, your lordship,
Not-
438 application. I'm here by filing a 438 application only, your lordship.
You don't have a case
Lordship,
because now the law is settled
lordship,
that even if you are shown as an absconder,
lordship,
court would issue summons to you.
lordship,
And then you can appear before the court and pray for bail.
lordship,
You have prayed anticipatory bail,
lordship.
therefore it was rejected.
Lordship, but if I appear before the court, your lordship, they will arrest me, your lordship. In most of the cases, it happens, your lordship.
On that plea, yes, heard Mr.
Your lordship, but the 164 statements also clearly states that,
No, suppose there is no material against you,
lordship,
but charge sheet has been laid against you
lordship,
and there is no apprehension of being arrested
lordship.
because court has issued summons to you or not.
Your lordship, till now, I have not got summon. Till now, I have not got summon, your lordship. But I have been informed, your lordship, the next date is on February by some counsel, your lordship, obvious, your lordship. So no such summon has been received as being instructed by
So
me.
why are you apprehending that you may be arrested?
Lordship, because your lordship, because I have been shown as an absconder and the case has been filed under
Then
section.
apprehension is not reasonable apprehension. Heard learned counsel for the, heard Mr. I. Hussain, learned counsel for the petitioner. This application under section 438 of the Code of Criminal Procedure, 1973 has been filed by the petitioner, namely Ilyas Khan, who is apprehending his arrest in connection with PRC case number 1426/2022 pending in the Court of Learned, Chief Judicial Magistrate Sonitpur, Tejpur, corresponding to the Tejpur PS case number 1988/2021. Learned counsel for the petitioner has submitted that the petitioner, before moving this court, had approached the Court of Learned, Assistant Session Judge Tejpur, by filing an application under section 438 of CRPC, which was rejected by the said court by order dated 7/12/2023. Learned counsel for the petitioner has also submitted that in the charge sheet which has been laid in the PR case number 1426/2023 under section 366 of the Indian Penal Code, the present petitioner has been shown as an absconder in column number 2 of the charge sheet, and therefore the petitioner apprehends that he may be arrested in connection with this case. On a specific query by this court, learned counsel for the petitioner has submitted that the petitioner is not aware of the fact as to whether any summons have been issued against the petitioner or not at this stage. However, he has submitted that the next date of the PRC case number, PR case number 1426/2022 is fixed in the month of February. Stop. I have also outlined additional public prosecutor. In this case, it appears that that though the charge sheet has been laid against the present petitioner under section 366 of the Indian Penal Code, showing the present petitioner as an absconder in the charge sheet. However, it is a settled law that the trial court would first issue summons to the present petitioner. And as the petitioner is not aware of as to what processes have been issued against the present petitioner at this stage, his apprehension of getting arrested in PR case number 1426/22 does not have any basis. Therefore, this court is not inclined to grant a favorable order under section 438 of the Code of Criminal Procedure 1973 to the present petitioner at this stage. This anticipatory bail application is accordingly dismissed.
Made, please, your lordship. Lordship 438 bail application, lordship, since allegation is 376D is there, lordship, case day may be called for,
Heard
lordship.
Mr. B. Chaudhary, learned counsel for the petitioner, also heard Mr. K. Das, learned additional public prosecutor. Considering the nature of allegations leveled in the FIR, perusal of the case diary would be necessary. Hence, call for the case diary.
22.
Fixing 22/1/2023 for case diary.
Highly obliged.
24.
May it please your lordship. Lordship, this is a 438 bail application, lordship. Here FIR, lordship, will find on page 13, lordship. Here the petitioner is a juvenile, lordship. Now, lordship, allegation in the FIR on page 13, lordship, it's a complaint case filed before the lordship, judicial magistrate, lordship, Borpeta, lordship. So thereafter, lordship, it is forwarded to the OC for investigation of the case, lordship. Basic allegation that, lordship, this juvenile, lordship, fall in love with the informant daughter, lordship. She is major. Now, in the same.
No, but the question is, the question as to whether 438 lies in.
Lordship, in juvenile case, lordship, apprehension, arrest is there, lordship.
No.
If arrest is there, lordship, apprehension must be there, lordship. There is
But-
no bar
but
to arrest this person.
There is a finding of a concurrent bench of this court that anticipatory bail does not lie, and in case of juvenile, and there is a finding of this court that it lies,
Yes,
and matter has been referred to
larger.
larger bench, and
Yes,
it is pending.
Since, lordship, even, lordship, this matter was raised a day before, yesterday before the Supreme Court, lordship, that also, lordship, that matter was referred to the High Court also, lordship, to decide regarding the section 15 of the Juvenile Justice Act case, lordship.
Supreme Court has said something.
No, that was not, lordship, till it's reported in libel, lordship.
You have to come up, because the matter, whether there are conflicting judgments
Yes,
of
sir.
various high courts
Yes, lord.
as to whether,
Yes, lordship.
and our high courts also, I know about two judgments. The earlier judgment says that anticipatory bail does not lie.
Yes, lordship.
So we have to go by that judgment unless a
But, lordship, in the
Judgment of
Juvenile Justice
larger
Act,
bench.
there is no specific bar, lordship, like in
No,
FTC
no,
say
I
against
understand that.
scheduled caste and scheduled tribe, lordship. There are
Uh,
18 say, lordship, it is specific bar. Here in juvenile, that is not there, lordship.
But when the matter is pending before,
Now, Lordship, there are no coercive action against this person, Lordship. Even Lordship, a record of the case, Lordship, the parents already will, Lordship, settle the matter, Lordship, the affidavit, the father has, the informant, complainant
oh,
has.
Mr. Chaudhary, I have only one option,
Yes,
either to refer it to a or placing the matter before larger bench,
yes, Lordship.
or you have to come up with whether any direction, whether any guideline from Supreme Court is there or not.
Yes, Lordship, then I'll try, Lordship. Then
You
I'll-
go through,
Yes, sir.
we will fix this matter later on, after Bihu.
Yes, Lordship.
On request of learned counsel for the petitioner, let this matter be listed after Bihu vacation.
But till that, Lordship, no coercive action against this petition, Lordship. That can be taken, since the matter is sub judice, Lordship, before this court, Lordship.
Nothing,
Yes.
when
On 19, Lordship.
it would not be proper on my part, when a coordinate bench has held that
Yes,
it does not lie. Unless you let this matter be listed after Bihu vacation.
can it be date fixed, Lordship?
When do you want it?
19, 20?
On 20th of
28 is the holiday. Saturday.
23rd, on 23rd January.
High level.
May it please your lordship. 438 application lordship. The type copy of FIR is at page 9 lordship.
P95. Yes,
Here in this case, Lordship, the informant make out a case of dacoity, Lordship, but it was originally it was a case of accident, Lordship. The informant alleged that the informant, while coming through National Highway number 39 in the night, Lordship, from Karbialang to Golaghat, Lordship, the petitioners restrained him on the road, Lordship, and try to snatch something from him, Lordship, and snatch his mobile phone also, and subsequently which was found on the road, Lordship, the mobile phone. Here the case is that, Lordship, the petitioner number 1, the vehicle registration number which has been mentioned in the FIR, he registered in the name of the petitioner number 1, Lordship, and mother of the petitioner number 1. He along with 4 friends, Lordship, while going towards Lordship, Golaghat through from Karbialang, Lordship, the informant who was also coming from same direction, Lordship, applied his brake of the vehicle, Lordship, in front of the vehicle of the petitioner, Lordship. He did not allow the petitioner to move the car ahead of the car of the informant, Lordship. He applied his brake, and there, as if he is playing the car race with the petitioner, Lordship, and the petitioner could somehow able to overtake his car, and the informant thereafter knocked the car of the petitioner from backside. Thereafter, some altercation, and the petitioner informant lodged the FIR against the petitioner, Lordship. Here in the Lordship,
but that is not the fact. In FIR, something else has been mentioned.
he stated that he tried to snatch away the chain, Lordship. And one thing, Lordship, kindly point out here, the person who in committing dacoity snatched something and subsequently throw away on the road, which was found by the informant later on. Here he himself mentioned, Lordship, that his mobile phone was found subsequently later on the road, Lordship. If someone tried to snatch something in committing dacoity, he never would throw it on the road, Lordship. There was just merely a accident. There was a accident and some altercation between them. Nothing was happened, Lord. Tender is it boy, Lordship. If there may be call for, in the meantime, they may be protected, Lordship. Their tender is it boy, Lordship. It was not a case of dacoity, Lordship.
No, after perusal of the case.
So kindly appreciate one thing, Lordship. Here the informant himself stated that his mobile phone was found. If someone committing dacoity snatch something, he will never
throw it on the road, or he will never
No,
get
but
it
that
back.
is the subsequent.
And here allegation is try to snatch, Lordship. If 5 person wanted to try snatch something from one single person,
There is an
easily they
allegation
can
of
take it out.
assault also.
Assault, Lordship, that are exaggerated, Lordship, allegation, Lordship.
So we
for-
have to
For
verify.
making out a case of dacoity, Lordship. Here situation is, Lordship, is similar to dacoity, Lordship. There are 5 person in the night and there was a assault also, but it is not a original fact, Lordship. They are
So
coming
we
from
have to
some-
see what is the original fact.
Lordship, in the meantime, if any adverse against the petitioner
Because
will found,
allegations are grave.
yes, Lord, allegation are, that I admit, Lordship. Allegation are grave. If anything found in the case, your Lordship may vacate our interim order also, because they are tender as a boy. And
Heard, Mr. B. I will go through the case diary. I will fix a short date.
it's a case of Gola, Bogija.
Heard, Mr. B. Halder, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Considering the nature of allegations leveled in the FIR, perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call
19.
for the case diary. Fixing
19.
19 for case diary.
In the meantime, Lordship, some protection, at least. In the meantime, kindly, Lordship. If anything found, we may vacate the.
No, not blankly. I have to verify. Your submission is that the allegations are exaggerated.
Some allegation are exaggerated. There was
That
also
has
case
to
of
be
it's true.
verified.
But if someone while committing dacoity
On-
snatch something, it
on
will never
nine-
get.
On 19.
Item 26.
May I plead your lordship? 438 bail application matter offense under section 326 and 307. Kindly call for the case diary along with injury report, my lord.
Heard Mr.
R.
R.
Sharma.
Sharma, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Call for the case diary along with the injury report. Fixing
22.
22-1 for case diary and
Obliged.
injury.
Item 27.
May I please, your lordship? Lordship 438 application, this translated copy of the FIR is in page number 9. And we come to page number 9. May I read that? Lordship? Yeah. So with due respect, I would like to state that I cultivated 2 acres of land with payee, but some unknown person continuously kept on slashing payee from approximately 3 quarters of my cultivation.
Grievous injury is alleged.
Yes, Lordship, just my argument is that, Lordship, the 2 acres of land that the informant mentioned, and in the 3 quarters of his cultivation, he told that someone has been stealing his payee. Now, the point here is that 3 quarters of land, your Lordship, is an alleged plot of government land, where both the petitioner as well as the informant are counterclaiming each other. Now, that day, what happened? He came to, the accused just came to slash the payee that he, robbed. Now, after that, what happened? When he was denied, he was restricted. Some alterations took place, Lordship. As a result of which he was having that payee chopper, in which in Vernacular we say the kasi. So because of some alterations, some hurt was caused, but that is not a grievous injury, Lordship. And because it is, Lordship, he is a poor farmer and the seasonal harvestation is going on. So kindly some interim protection may be granted. Otherwise, I have not argued because 3 quarters of cultivation land is the alleged government plot of land.
No, I'm not on that. Not. I'm on the fact whether grievous injury has been.
Lordship, as per my knowledge, because you was holding the Kasiani in village areas, you know that people have alterations regarding disputes of land. So while he was holding the Kasi, because of some alterations, he got hurt. That was not a grievous injury, Lordship. So that is the reason.
That has to be
That is, and he's
after case study.
some protection may be given because the seasonal harvestation is also going on. So if he cannot earn in that point of time, then it will be difficult for him to,
Mr. D. Sharma, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Considering the nature of allegations leveled in the FIR, perusal of the case diary would be necessary for consideration of the instant bail, anticipated bail application. Hence, call for the case diary. Fixing
22nd.
22nd.
18, Lordship.
18. Fixing 18 for case diary.
28.
May I please, Your Lordship? Your Lordship, kind of, at page 10, Annex 1. Actually, put this on there. In this case, Lordship, the petitioner have been made. May I read the FIR, Lordship? I beg to
Three
state that
92,
392, Lordship.
whether case diary would be required.
Lordship, already we have approached the session court, Lordship, they granted peer as well, and our statements were recorded, Lordship. Whether is it
You have been granted pre-arrest bail.
peer as bail, not the interim bail.
Then
After the CD, that was rejected.
therefore case diary would be required.
Lordship, since we have, our statements have already been recorded, Lordship.
Why it was rejected? Where is the rejection of?
Rejection order, we did not get the certified copy. It is not uploaded in e-courts also.
No, but the fact that your anticipatory bail application has been rejected after perusal of the case diary
Lordship. That
itself
only
requires.
my instruction is that only that some incriminating materials were found. Only that must. My instruction is that.
Let us,
Later case there may be called for, but in interim we may be protected, Lordship.
no.
Already our statements have been recorded, Lordship.
But your interim was rejected by the
Yes.
trial court by after perusal of the case.
Session
diary.
court, Lordship.
Heard Mr. D. Borwa, learned counsel for the petitioner. Also heard Mr. A.K. Das, learned additional public prosecutor. Since the petitioners who have approached this court under section 438 of the Code of Criminal Procedures, Procedure 1973, were earlier granted anticipatory bail by the learned Session Judge Sibsagar, and same was rejected after perusal of the case diary, hence the perusal of the case diary would be necessary for consideration of the instant anticipatory bail application. Hence call for the case diary fixing
22nd.
22nd for case diary.
Masura.
Item 29.
Application, Lordship. Quoted application, Lordship. FIR page 8, Lordship. I read, Lordship.
326 and
Lordship.
307,
Lordship.
whether case diary would be required.
Lordship, what happened in this case on the day of 31st night, Lordship, both the petitioner and the victim, Lordship, they had dinner and thereafter they consumed alcohol, Lordship. Thereafter the petitioner, they are came to the house of the petitioner and thereafter some altercation took place. Thereafter, on the sudden provocation, the petitioner pushed the victim, and as a result, he fall in the tin of the barricade of the gate. As a result, sustained some injuries, Lordship. This is the main fact of the case. Due to influence of alcohol, the happen is gone. It is true he is injury, Lordship, but he is not grievous injury, Lordship. He is fall in the tin of the barricade of the gate.
Case diary would be required.
Kindly protected till date, Lordship.
Not now. Heard Mr.
B Islam.
Heard Mr.
B Islam, Lordship. B Islam.
B Islam. Learned counsel for the B Islam, learned counsel for the petitioner. Also heard Mr. K.K. Das, an additional public prosecutor. Considering the nature of allegations leveled against the petitioner in the FIR, perusal of the case diary would be necessary. Hence call for the case diary fixing 23-1 for case diary.
Till that, Lordship, I am protected, Lordship. This is the influence of alcohol, Lordship. That's why
No, we have
he
to
is not
verify.
intentionally attacked, or neither he attacked with the down, Lordship.
We will have to verify. You are admitting that he sustained injuries.
Injury, that is simple injury.
Now, whether it is grievous or simple, that we have to see.
Along with the injury report, make file.
Along with the injury.
Much obliged.
Item 30.
May I please, your lordship? Your lordship, 438 application under Chungazan PS, Golaghat district. The present petitioner is the apprehending arrest is the owner of the seized articles, your lordship. The learned JMFC has already granted Zimma of the articles based on certain stringent conditions, your lordship. And in this present petition, your lordship, there is no way criminal involvement,
and the question of theft was ruled out by the learned JMFC, Your Lordship. I have annexed the order also.
Please, please.
What is the allegation?
Allegation is under allegedly Burmese Supari, tax evasion and theft of Burmese Supari. Your Lordship may peruse page number 19, Your Lordship.
You are owner of the,
One of the seized articles, seized Supari.
where is the FIR?
FI is page 14, Your Lordship.
What is the allegation?
Your Lordship.
What is the
Allegation,
allegation?
Allegation is under section 120B, 284, 379, 406, 411, 413, 420 IPC, Your Lordship. Allegation is that of transporting illegal Burmese Supari into the state of Assam from Nagaland and not paying the taxes, Your Lordship. However, the petitioner has stated before the learned JMFC that he would pay the taxes within 7 days, Your Lordship, after the receipt of Jimma. And the Jimma was granted on 6/1, Your Lordship, 6th of January 2024.
Let him appear. Third, Mr.
A. Iqbal.
A.N. Iqbal, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Pankaj Kolita, who is apprehending his arrest in connection with Sumajan PS case number 15/2023 under section 120B/284/379/406/411/413/420 of the Indian Penal Code. The gist of accusation in this case is that on 26/9/2023, one Pavan Devraja, ASI of Police of Sumajan Police Station, lodged an FIR before the officer in charge of Sumajan Police Station, inter alia, alleging that on receipt of information through reliable sources, a Naka checking was conducted at Hologuri under Sumajan Police Station. And during Naka checking, a white color dumper bearing registration number AS04BC 6630 was intercepted, and several bags of areca nuts suspected to be Burmese Supari were found concealed in the said vehicle. And during interrogation, the driver of the vehicle was unable to produce any document regarding the seized areca nuts. The learned counsel for the petitioner has submitted that the petitioner is the owner of the seized areca nut, which he has purchased from
Sumaya Betel Nut Factory.
From one Sumaya Betel Nut Factory. And in support of his submission, learned counsel for the petitioner has produced the cash memo of the said Betel Nut Factory, showing sale of betel nuts, sale of 7 tons of betel nuts to the present petitioner by Somaya Betel Nut Factory. Learned counsel for the petitioner has also submitted that In the meanwhile, learned judicial magistrate first class, Dhansiri Sarupata, has already granted Jimma of the seized betel nuts to the present petitioner on a prayer made by the present petitioner for Jimma, and in the order granting Jimma, that is order dated 6/1/2024, passed in Sumajan PS case number 15/2023. The learned judicial magistrate first class has also ruled out any, where is the observation?
Your Lordship, page number 19,
Second paragraph.
second paragraph.
Ruled out the allegation regarding theft of the said betel nuts on the basis of the documents produced by the present petitioner. It is also submitted by learned counsel for the petitioner that petitioner was granted Jimma of the said seized betel nut with a condition that after receiving the Jimma of the said betel nuts, the petitioner would pay the requisite tax within a requisite tax of the said seized betel nuts in due course as per the provisions of law. Learned counsel for the petitioner has also submitted that the petitioner would cooperate in the investigation. Whether CD would be required or we can dispose it of.
Lordship, schedule will be required whether requested payment has been made or not.
On the other hand, an additional public prosecutor submits that case diary of submits that in view of the allegations leveled against the petitioner, the case diary would be required. Hence, call for the case diary. However,
On 38.
on
of
31/2023.
31 not 30. Lordship.
3/01/2023. However, in view of the fact that the Jimma of the seized betel nuts have already been granted to the present petitioners, and apparently it appears that the petitioner is the owner of the said seized betel nut, he is directed to appear before the investigating officer of Sogajan PS case number 15/2023 within a period of 10 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with Sogajan PS case number 15/2023, the above named petitioner shall be allowed to go on interim bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Number 1 and number 2. Let this case be listed again on 30 January 2023.
Deeply obliged, Your Lordship.
For 38 application Lordship, here Lordship, before going to the FIR, just I'm placing a fact Lordship. After registering of the case Lordship, I filed bail application before the learned session judge Lordship. And during pendency of my application, charge sheet was submitted. And on that basis, my bail application was rejected and now summon is issued. Now my apprehension is that the case is pending before the committal court. And if I appear in terms of that summon, I will be taken into custody. So I may be protected, I will appear. And the sections are Lordship 325, 307. Your lordship will find order
What
of
happened to the bail application? Anticipatory bail.
anticipatory bail before session judge because charge sheet was submitted, that was rejected. That was certified copy I am just sending all of you, lordship.
What is the punishment?
Uh,
307?
325 lordship it is there, but 307 is there, lordship, that flag.
307 life is there.
Yes, and sessions triable case. So if I appear before the committal court, before committal.
No, whether the embargo of 437 1A is applicable, whether
Yes,
committal court cannot grant bail
Not
in
granted.
307 matter.
307 is there, like. And your lordship's order is there, just this one.
Heard Mr. A. Ahmed and counsel for the petitioner. Also heard Mr. K. K. Daslan, an additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973 has been filed by the petitioners, namely 1, 2, 3, and 4. Who are apprehending their arrest in connection with PRC case number 17/24 arising out of Nilam Bazar police case number 141/2023 under section 341/326/307/34 of the Indian Penal Code. What was the injury?
Injury grievous with sharp weapon. And only finger of that he sustained cut injury in the finger in the FI itself, which is mentioned, lordship. In page 14, your lordship will find. And
Allegation is also that on the left side of the chest of the husband by means of a dowel on chest.
No, but merely because the trial court may not give you bail because of the embargo. But otherwise, you must be entitled to get bail.
otherwise, it is there, lordship. And, but my bail application was rejected by the landed session because charge sheet is submitted. I have given the copy to your lordship, certified copy of that order. And now my apprehension is that as my bail application was rejected by the landed session judge, the committal court may not grant me bail.
No, that is okay.
Okay.
But otherwise, by your conduct, if your conduct is such that you should not be granted bail in a non-bailable offense,
Lordship.
then merely because of the embargo, that committal court cannot grant you bail.
Sorry.
This court will not grant automatically.
Lordship, that I understand. Lordship may in that case.
You
Lordship
must
may-
have a case to.
Lordship, in that case, Lordship may kindly see that page 22, the first FIR. Here in this case, we lost in the month of March case against them, Lordship. They assaulted one of the petitioners seriously, and they were putting pressure on the family members of the petitioners to withdraw that case, Lordship. And because of that, the present altercation took place, Lordship. They came forward to assault and public gathered there, public tried to apprehend them. And when public snatched the dagger from his hand, Lordship, he sustained cut injury in his hand. The prior point of time, the petitioner number 2 was assaulted by the informant side. And FIR was lodged by petitioner number 1. Page 22, your lordship will find. Informant is Nurul Islam, he is petitioner number 1. And victim is Bodrul, he is petitioner number 2 before your lordship. So because of that reason, they were putting pressures.
What happened to your case?
My case is charge sheeted and their lordship summon is issued, and now they are pressurizing that you do not go to the court and do not depose before the court. They are pressurizing us. Lordship. Because of that, they tried to assault us. Public gathered there, and when public snatched the dao, he sustained cut injury in the hand. Lordship. So whatever is there, I will face the trial. Okay? I will prove this document before the court. And there was no 307, Lordship. Because public snatched the dao.
What was found during investigation?
During investigation, Lordship, in the FIR, 6-7 persons are named, and out of them, Lordship, against 2 Lordship FIR is submitted. And that charge sheet your Lordship will find at page 25. And even they alleged about 326, that is also not there. Blunt weapon is found, therefore 325 is added. Thou is not there. Probably that cut injury was not proved during investigation. Page 25 is the finding of the investigating officer. And page 26 is against 2 FIR is also submitted. My case is that because of that first case which I have lost, where petitioner number 2 sustained grievous injury, they are continuously putting pressure on us. But by for lodging this case, now they will say the petitioners may not go to the court because of the pending of this case.
Okay. None. Of the Indian Penal Code. The list of accusation in this case is that on 4/8/2023, one Angur Nesa lodged an FIR against 6 named accused and 2-3 other persons not named in the FIR, inter alia, alleging that the petitioners assaulted the husband of the first informant and by means of a dao and caused grievous injuries on his person and also assaulted some other persons. On receipt of the said FIR, the FIR was lodged by so and so before officer in charge of Nilam Bazar Police Station. On receipt of the said FIR, Nilam Bazar PS case number 141/23 was registered and investigation was initiated. Ultimately, on completion of investigation, charge sheet was laid against the present petitioners under section
Page 26, your lordship will find it.
under section
120B.
120B/341/325/307 of the Indian Penal Code. Learned counsel for the petitioner has submitted that the petitioner had earlier approached the Court of Learned Additional Sessions Judge Karimganj by preferring an application under section 438 CRPC. However, same was rejected on the ground that by the time the petitioners preferred the said application, charge sheet was already laid against them. Learned counsel for the petitioner has also submitted that now the trial court has issued summons against all the present petitioners. And next date is fixed on
19/2/2020.
19/2/2022. Next, in which case number?
Page 36, your lordship will find. PRC case number 17 of
In
2020.
PRC case number 17/2024. Learned counsel for the petitioner has also submitted that as the committal court is a court of Chief Judicial Magistrate, that is Chief Judicial Magistrate Karimganj. And as one of the section under which the charge sheet has been laid is under section 307 of the Indian Penal Code, the maximum punishment for which is life imprisonment. Hence, the committal court, hence it is submitted that committal court may not grant bail to the present petitioner due to the embargo of section
209.
209
Lordship, of CRPC. 8.
No, due to the embargo of section 437. In 437 embargo is there.
Photo 27 is also there, lordship. That
437 within bracket 1 within bracket small 1 of the Code of Criminal Procedure read with section
209.
209
A. Small
A of the said code as the
209.
as the Court of Learned Chief Judicial Magistrate Karimganj is only a committal court with limited powers. It would be left with no other option but to remand the present petitioners in the event of their appearance before the said court to be custodied. Hence the apprehension. Hence the petitioners are apprehending that they may be detained even if they appear before the learned committal court in pursuant to the summons received by them. Learned counsel for the petitioner has also submitted that prior to the lodging of the instant application by the first informant, the petitioner number 1, Nurul Islam, had on 24/3/2023 lodged an FIR against the
Husband of the informant.
husband of the first informant, in which case the charge sheet has already been laid and summons have been issued against the accused persons. It is submitted by learned counsel for the petitioner that the instant case has been lodged by the husband of the present petitioner. Instant case has been lodged when there between the present petitioners and the husband of the informant, and due to the intervention of the public, the husband of the first informant sustained injuries
In his
No.
hand.
in his hands. Learned counsel for the petitioner has submitted that the petitioner would cooperate in their trial and their custodial detention is not necessary. And as the case, there is a cross case also, it is not a cross case.
Not cross case.
There is a case pending against the present petition, against the husband of the first informant also. There is unlikelihood that any of the witnesses from any side would be won over by either of the side. And therefore, there is no justification to keep them in custody during the trial. I have considered submissions made by learned counsel. Whether, what will we do? We will dispose it off. We will dispose it off. I have considered the submission. I have also heard learned additional public prosecutor. I have considered the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor. In this case, though summons have been issued against the present petitioners, which at the first look may not give an impression that there is any apprehension of petitioners getting arrested. However, if we consider the fact that charge sheet has been laid, inter alia, under section 307 of the Indian Penal Code also, which is exclusively triable by Court of Sessions and for which the maximum punishment prescribed is life imprisonment. And hence, due to the embargo laid down in section 437 clause 1 within bracket 1, Roman 1, and section 209A of the Code of Criminal Procedure, the committal court, which is the court of learned Chief Judicial Magistrate Karimganj, may not be in a position to grant bail to the present petitioner, even if they appear before the said court in pursuant to the summon received by them. And hence it appears that the apprehension raised by the present petitioners of getting detained appears to be genuine. In view of the above discussion, the anticipatory bail is hereby disposed of with a direction that the present petitioner shall appear before the court of learned Chief Judicial Magistrate Karimganj in compliance to the summons received by them on
19 to
2023, and in the event of their appearance before learned committal court, the said court shall allow the above named petitioners to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction that number one, that the petitioners shall cooperate in their trial and shall appear before the trial court as and when so required by the trial court. Number two, that the petitioner shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade such persons from deposing against the petitioner in the pending trial against them. With above observation, this anticipatory bail application is disposed of.
Lordship, my objection may be recorded on the ground that 307 is there, Lordship. And moreover,
though learned additional public prosecutor oppose the grant of bail to the present petitioner on the ground that Section 307 of the Indian Penal Code is also involved in this case. And as only summons have been issued against the present petitioner, however, no paragraph.
Obliged, Lordship.
On this item number 2, for hearing the order.
68 bail application 2917. For reasons mentioned in the judgment, in the order, the petitioners are allowed to go on bail of rupees 50,000 each with two sureties of like amount, one of whom should be government employee, subject to certain conditions mentioned in the orders. And criminal petition number 4, for reasons mentioned in the judgment, this criminal petition is dismissed.
Obliged.
May I please your lordship, my lord? Ma'am, I will be excused, my lord, to make a mention out of turn. My lord, on 8th of January, matter was listed as item number 51. But due to early rise of the court, matter could not have been taken up. So, my lord, this matter may be listed, my lord, 12th. Matter is very urgent otherwise, my lord. I'm extremely sorry, my lord, for making mention out of turn.
No. Okay.
Item 21.
May I please, lord? My lord, here, my lord, three petitioners are all, my lord, women, my lord. One day, my lord, FIR and counter FIR is lodged, my lord. One day, my lord, suddenly, on receipt of, my lord, some vague information, my lord, page 15, my lord. Without, my lord, warrant, my lord, suddenly they raided the, my lord, house of the petitioner, my lord. And found, my lord, no such betel nut there. But they started, my lord, seriously assaulting, my lord, even, my lord, one, my lord, petitioner's relative, my lord, ER lap is, my lord, already clear, my lord. Page, my lord, 22, I have an next one.
No, I could not get it. Petitioners?
Petitioners, my lord, their house, my lord, somebody informed, my lord, that, my lord, they are, my lord, dealing with, my lord, the Burmese Supari, my lord. Then, my lord, police, my lord, on the Barwell
Who
instruction.
raided? Police raided.
Raided, my lord.
Okay.
And, my lord, they are found, my lord, no Burmese Supari, my lord. But they are local betel nut, my lord. This is rural area, my lord. Everybody, my lord, develop this kind of, my lord, betel nut, my lord. They tried to, my lord, take this, my lord. And under this circumstance, my lord, police started assaulting, my lord. And at this juncture, my lord, even, my lord, one, my lord, family members, my lord, ER is also, my lord, cleared, my lord. I have a next, my lord, page 22, my lord, this is the photograph. Even, my lord, if they found, my lord, any information, they could have, my lord, informed this, my lord, at best, my lord, to the, my lord, excise department, my lord. It is a, even assuming, my lord, this is a true allegation, my lord, information, my lord, this is a purely case of, my lord, excise department, my lord. And only somebody, my lord, informed, my lord, and they started assaulting, my lord.
They means police.
Policeman.
This earlobe is of who? Which petitioner?
My lord, they are, my lord, one younger sister, my lord. And in this regard, my lord, they have also submitted one FIR, my lord, page 16, my lord.
What happened to other accused persons?
My lord, as per my instruction, my lord, male member, those who are, my lord, they surrendered before the, my lord, court, my lord, and they were subsequently granted bail, my lord.
But here I only point out that, my lord. 353 is there. If I look into the FIR, lordship, the FIR has been lodged by one woman inspector, lordship. And she has stated that the accused person started on the last part of the first paragraph, lordship. Last four lines. Started physically assaulting, even they have dragged me by pulling my hair of the woman inspector and torn my uniform and also snatched away my belongings.
Not regarding this petitioners. This is, my lord, a barrage, my lord, bag allegation, my lord.
It will be ascertained by the CD, lordship. It is vague or not.
Case diary.
Lordship.
The short date we are fixing.
My lord, in the meantime, my lord, there may be my woman, my lord, they are, my lord. And
The
allegation
woman
is not
inspector-
serious, my lord.
inspector is also woman.
Even, my lord, even, my lord,
Inspector is also
assuming, my lord, this allegation, my lord, and there, my lord, this action is correct, my lord. Lordship, kindly evaluate. Apparently, this is illegal, my lord. Private property entered, my lord, and snatching away, my lord, without any warrant, my lord.
When can you produce the case diary?
On 22nd, lordship.
My lord, this is
Hailakandi,
their
lordship.
case, my lord,
Hailakandi,
and, my lord, we have also filed, my lord, our FIR, my lord.
Hailakandi, lordship.
My lord, apparently, my lord,
FIR against police.
police, my lord.
Where?
My lord, yes, my lord. My lord, assuming, my lord, this is correct, my lord. Lordship, kindly consider, my lord, Burmese Supari, how they can ascertain, my lord. And how, my lord, they will say, my lord.
No,
this
no,
is
I'm
stolen.
not on that. Burmese
Yes, my
Supari.
Lordship.
I'm on assault on woman police
Lordship.
inspector.
That's lordship.
You dragged and assaulted woman police inspector.
lordship.
That is the offense.
Yes, my lord.
Burmese Supari is not.
Lordship.
Yes, my lord. But here, my lord, they entered, my lord, even, my lord, without any prior information and warrant,
But
my lord. And-
Whatever may be,
Police
my lord.
may search under certain circumstances, even without
Yes, yes, my lord,
Warrant.
definitely, my lord. But here, my lord, they all, my lord, they
short date and case diary would be necessary.
specific, my lord, allegation is not against this
22nd,
petitioner.
lordship.
They are women, my lord.
22nd.
No, that I'm concerned that petitioner are women, but the victim is also woman.
Lordship.
The heard Mr. A.M. Bordhuya, learned counsel for the petitioners. Also heard Mr. K.K. Das, learned additional public prosecutor. Considering the nature of allegations labeled in the FIR against the present petitioners, the perusal of case diary would be necessary for consideration of the instant bail application. Hence call for the case diary fixing
22nd.
22-1 for case diary.
Item 42.
On that day, my lord, the interim may be considered. Kindly, may I-
On that day,
Oh. আজকে না বলছি বেয়াদবিলে রিজেক্ট করে
Obliged.
No, beyadigli to reject করতে হবে May I please your lordship, it is a 438 application lordship. Lordship will find the FIR on page 11 lordship.
Assault of grievous.
No, not at all lordship, cross FIR is also there lordship, my wife also lost the FIR lordship, that lordship will find on page 14 lordship, it is a boundary dispute lordship. Between both are neighbor lordship, boundary dispute lordship, so some scuffle was there lordship and fell down lordship, that is the case. No injury at all. Lordship, when the CD will come lordship, report will be there lordship will find. No, absolutely no injury.
Assault with a shovel.
No, absolutely not.
No, you read the FIR.
No, FIR I have there lordship, but as per information lordship, no injury.
No, whether your information is true or false, CD.
No, that will come, till then lordship can be used also there lordship. Page 14 lordship will kindly see it is a cross FIR lordship, it is a boundary dispute lordship regarding construction of a wall lordship. This is from our side lordship, my wife has lost it.
No, but the allegation is grievous injuries there.
Absolutely not. The CD will come only for few days, Lordship, till the CD comes, Lordship. I'll appeal, Lordship. Only till the CD comes, Lordship. I'm not. CD, everything will be there, Lordship.
After perusal of the case.
Lordship. Till then, Lordship.
After perusal. Heard Mr. S. Munir, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant bail application. Hence call for the case diary. Fixing 19-1 for case diary.
Lordship. Much obliged, Your Lordship. Much obliged.
Item number 40.
May I please, Your Lordship?
CD not available.
My lord, today is fourth occasion, my lord, for sitting, my lord. And my lord, 76 days behind the bar. He was arrested on 27/10, my lord.
What is the offense?
Offense is, my lord, under section 307, my lord. And my lord.
354 is also there.
Yes, my lord.
354.
My lord, there are, my lord, 3 accused person, my lord. Except this petitioner, my lord, other accused are granted bail by the district judgment.
Why
And-
you?
And my lord, he could not, my lord, approach the district court, my lord, due to pendency of this petition. And 76 days behind the bar.
You should have approached sessions court first before coming to this court.
Last 2 months, my lord, the bail petition is pending before this court. Fourth occasion, my lord.
Therefore, the lesson is you should first go to sessions court.
Yes, my lord, I would
And
like
then
withdraw
come to
petition.
this court.
Yes, my lord. I would like to withdraw this petition.
Heard
My lord,
Mr.
fourth judicial order has been passed. my lord.
Heard Mr.
This is amounts to contempt of court. my lord.
S.A. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Sanidul Islam, who has been detained behind the bars since 27/10/2023, within bracket for last 76 days in connection with Jorhat PS case number 492/2023 under section 354/326/307/34 of the Indian Penal Code. The gist of accusation in this case is that on 25/10/2023, one Shri Monu Das Chaudhary lodged an FIR before the officer in charge of Jorhat Sadar Police Station, inter alia, alleging that when the first informant was
FIR, my lord, vernacular at page 13.
when the son of the first informant went to see Durga Puja at Gaurali near V-Mart at Jorhat, some unknown youths had teased the friend of the son of the first informant, and they also assaulted the son of the first informant with a knife, due to which the son of the first informant received severe injuries. Stop. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bar for last 76 days, and in the meanwhile, the other co-accused persons have already been granted bail by
District Judge Jorhat.
the learned Sessions Judge Jorhat. On the other hand, learned additional public prosecutor has submitted that though the case diary was called for, however, same has not yet arrived and has prayed for another date for producing the same.
Hello,
The learned additional public prosecutor has also submitted that no reason has been shown by the investigating officer for not sending the case diary. Considering the fact that in spite of repeated reminders, the case diary has not been sent consecutively for last 4 occasions.
Fourth occasion.
And in the meanwhile, other co-accused persons have already been released on bail. And considering the period of detention already undergone by the present petitioner, his further custodial detention does not appear to be necessary if he otherwise cooperates in investigation. Stop. In view of above, the petitioner, namely Sanidul Islam, is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Jorhat, with following conditions. Condition number 1 and condition number 2. With above observation, this bail application is hereby disposed of.
Obligement.
Item 41.
CD not available. May I please, Your Lordship? Lordship, in this matter, Lordship, FIR in this matter, Lordship, one person attacked the murder of the informant, taking the advantage of darkness with a sharp weapon. And that person was named and identified. FIR is page number 11. 71 days, Lordship, today. And that person was arrested and he got bail, Lordship. FIR
Where is the bail order?
AB, I have the BA number, Lordship. BA 4352 of 23. BA, Lordship, 4352 of 23.
Dated
Dated, Lordship, 2012-2023.
Atul, bail order to
Just a minute. BA 4352 of 23. Last occasion, Lordship, CD was received.
What is his name?
Name is Dipen Bonia. He is not named in the FIR, present FIR. FIR name person is Udit Das.
FIR name person is?
Udit Das, Lordship. And he was identified by one Bobita Das who accompanied the victim.
Udit Das has been granted bail.
Yes.
Okay, heard learned counsel for the heard Mr. H.S. Bora, learned counsel for the petitioner. This application under section 439 of the Code of Criminal Procedure, 1973, has been preferred by the petitioner, namely Dipen Bonia, who has been detained behind the bars since 1/11/2023, within bracket, for last 71 days, in connection with Behali PS case number 143/2023 under section 326/307 of the Indian Penal Code. The gist of accusation in this case is that on 19/10/2023, one Srimati Dimpimani Kanjarika lodged an FIR before the officer in charge of Behali Police Station, inter alia, alleging that the accused person named in the FIR, namely Shri Udit Das, had stabbed his mother from backside, as a result of which her mother sustained serious injuries. Learned counsel for the petitioner has submitted that the present petitioner is not named in the FIR, whereas the FIR named accused, namely Udit Das, has already been granted bail by a coordinate bench of this court by order dated 20/12/2023 in bail application number 4352/2023. On the other hand, learned additional public prosecutor has submitted that
Lordship, earlier the CD was there, but on 14/12, updated CD was called for with injury report, Lordship.
though on earlier occasions, case diary was available. However, an updated case diary was called for
With injury report, Lordship.
with injury report. And same has not been received yet by this same has not yet been received. And no reason has been shown by the investigating officer for not sending the updated case diary. Now, considering the fact that the FIR named accused Udit Das has already been granted bail by a coordinate bench of this court, as well as considering the fact that the petitioner has already been detained for last 71 days behind the bars. Also considering the fact that the prosecution side has failed to produce the updated case diary, this court is inclined to grant bail to the present petitioner. Stop. In view of above, the above named petitioner is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Bishwanath Charindi, with following conditions. Condition number 1 and 2. With above observation, this bail application is thereby disclosed.
Obliged. May it please your lordship, 439 application lordship, FI is at page 10.
Page
10 lordship.
Yes.
Okay, here the petitioner is security cum Chowkidar lordship of Mahalakshmi apartment lordship. Here the informant and the petitioner is always at a quarrel or a loggerheads because of the reason that the security used to close the gate at 11 and 12 o'clock of the apartment lordship. Thereafter, frequently the informant comes late, and so there used to be a quarrel. And lately, lordship, the alleged victim has been using his toilet cum bathroom. The man has been using the toilet cum bathroom. Due to this, also there is a altercation. And the incident, alleged incident, which has been said, it never took place.
When were you arrested?
Lordship?
When you were arrested?
On 2011-23.
2011, 51 days. Lordship.
Yes.
Yes, my lord, case they received, my lord, 164 statement and my lord, medical examination report is also available. Now, my lord, wearing apparels of the victims are also collected by police, and DNA sample of the my lord, accused persons also taken. Now that DNA report is, my lord, not yet received. Otherwise, my lord, from 164 statement and my lord, 164 victim is of, my lord, as per one, her age is 18 years, and she has implicated the present accused person. My lord, the victim is also a housemaid in the resident, in the flat of the my lord, informant, and the present accused person is the chowkidar of that flat. And my lord, from 164 statement, my lord, she implicated the present accused person.
And medical?
A medical examination report, my lord, on the next day, my lord, incident occurred on 18/11/23. On the next day itself, my lord, medical.
Now, whether, what is your submission?
My lord, as per medical examination report, my lord, your lordship may kindly peruse one. My submission is that, my lord, from statement of some of the witnesses also available in the case diary, my lord. And now after, my lord,
He is in jail from 20, some, if my lord DNA, my lord report, if from DNA, my lord, already prayer was made before the trial court, and thereafter, my lord, sample of my lord, DNA of the accused person was taken. And thereafter, death comparison till now not yet received. But from the medical report, medical examination, no any injury noted on her private parts at the time of the examination, my lord. And no any foreign material detected on her at the time of examination. Private part at the time of examination, there is no evidence of recent sexual intercourse. That is the, my lord, medical examination report on 19/11/23. Otherwise, my lord, from the my lord, statement of 164 statement and my lord, the statement of the witnesses, my lord, the present accused person has well, it seems to be committed the may not be, my lord, but from the definition
But
of
51 days.
yes, from the definition of 376, my lord, he may from there is material against the accused person. Actually, here in the FIR, we the last part we discussed the matter with our society and some of the
Mm-hmm.
society
164 statement also seek.
Yes. The independent witness, what's it, as it happened in a society, what's it? The breaking open of the door, what's it? Here the Sukidar can below not accused person with melanoma forcefully open the door of the apartment, what's it? And assaulted her. What's it? Here the sexual assault does not come from a medical report and breaking of an opening of a door at night, what's it?
But well, as per 164, my lord, statement, she stated that, my lord.
Independent witness will only provide a lot because there are other persons also present, lordship. And
that is a place is a residential flat, and my lord, that is, my lord, because the victim is also a housemaid in the residence of the informants. She cannot use the my lord bathroom because of the my lord western bathroom she cannot use, and for which my lord she used the my lord common toilet my lord used by the other security guard.
Now the
And-
statements are recorded.
Yes, 160.
Only DNA examination is.
Yes, only my lord, DNA sample were already taken from the my lord.
Because he has been detained behind the bar since.
For 51. Otherwise, my lord, material available, my lord, against the accused person.
Though medical is not supported.
Medical is not supported.
Heard Mr.
as this, my lordship, applying for D is here.
Heard Mr. N.
As this, my lord.
S. J. Sharma. S. J. Sharma, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Ramesh Borwa alias Ramesh Bej Borwa. You are 62 years old.
Yes, lord.
Ramesh Bej Borwa, who has been detained behind the bars since last 2011-2023 within bracket for 51 days in connection with Jalukbari PS case number 679/2023 under section 376/323/506 of the Indian Penal Code. The gist of accusation in this case is that one, Nilmi Kaur on 19/11/2023 lodged an FIR before the officer in charge of Jalukbari police station, inter alia, alleging that one girl who is the victim in this case, who work as maid in Mahalakshmi apartment, Sundarbari, was assaulted and raped by the present petitioner. Learned counsel for the petitioner has submitted that the petitioner is no way involved in the offense alleged against him, and false allegations have been made against the present petitioner, as he used to closed the gate of the Mahalakshmi apartment at
11 and 12 o'clock
at 11, in between 11 to 12 o'clock
at night.
at night, and the petitioner used to, and the victim used to come
Late.
late thereafter, after the closing of the gate, and therefore quarrel used to happen between them. And the petitioner has falsely implicated the present, no, and the victim and the informant has been falsely implicated in the present case. Learned counsel for the petitioner has also submitted that the petitioner has been detained behind the bar since for last 51 days, and considering the period of detention, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Jalukbari PS case number 679/2023 and has submitted that there are sufficient implicating materials against the present petitioner in the statement of the victim girl recorded under section 164 CRPC. However, learned additional public prosecutor fairly submits that the medical report of the victim girl, which was conducted
On the next day.
on the next day of the incident, does not implicate the present petitioner. Learned counsel for the learned additional public prosecutor has also submitted that the apparels of the victim as well as the petitioner has been seized by the IO.
No, my lord, only apparels of the victim, my lord.
Victim has been
And
seized
clothes
by
of the, my lord, the accused persons were taken after, my lord, making prayer before the trial court. My lord.
and the IO has and the IO is waiting for report of DNA cross matching
Yes.
of the victim sample as well as the petitioner sample. I have considered the submissions made by learned counsel for both the sides and gone through the materials available on the record, including the case diary of Jalukbari PS case number 679/2023. Though the present petitioner has been implicated by the victim in her statement made under section 164 of the Code of Criminal Procedure. However, considering the progress made in the investigation, as well as considering the fact that the petitioner has been detained behind the bar since for last 51 days,
51 days.
his further custodial detention does not appear to be necessary if he otherwise cooperate in the investigation. Hence, the above named petitioner is allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of London Chief Judicial Magistrate Kamrup Metro, with following conditions. Condition number 1 and 2. In terms
Alright,
of
sir.
observation, yes, bail application is dismissed.
Item 43.
May I please? Lordship, submitted matter of lordship. This was arrested on due to non-appearance.
Why you have not appeared?
My lord, he went to the Kerala for livelihood, my lord. After going to the Kerala, he stayed about 2 years, my lord.
Now,
But,
how many days you are behind the bar?
My lord, 86 days, my lord.
86.
My lord.
What is the offense?
Lord, 302 is there, my
302
lord.
is there, my lord. Now, till September 22, 10 PWs have been examined. My lord, the IO is also examined, my lord. Perhaps, my lord, by now, it is likely to be ended. My lord, prosecution witness is complete, my lord. Now, my lord, how many witnesses are there? It could not be ascertained because my learned friend has not annexed the, my lord, charge sheet, complete charge sheet, showing the list of witnesses. And the case diary is also not available in the, my lord, record. Only, my lord, trial courts, my lord, records have come.
No, now the question is, as 10 witnesses have already been
Already
examined,
examined.
if he, only fear is he may again abscond.
Yes, yes, my lord.
That is the fear.
My lord.
So if we release you, you will again abscond.
No, my lord, I am not assuming I will even present my
That
lord.
is your fear.
My lord.
Otherwise, he will not influence the witnesses.
No, almost, my lord, the case is complete, my lord.
No,
Look,
any time
normally,
of
normally,
my lord.
IO is the last witness. Here, my lord, IO has been examined. Let him approach before the trial court.
Why
But
trial
after-
court rejected?
And after getting bail, he will appear, my lord, till my lord 2022, my lord.
No, when the trial court rejected your prayer,
Like kindly see page 20,
20?
my lord, 30, my lord. Page 30.
November 23. November 23.
Page 30.
Now, whether my lord, the arguments are over by now, or
What is
What-
the stage?
Plus,
Present.
production of accused, my lord. Next date, my lord.
production of engagement means you, the petitioner.
Next
No,
date.
evidence complete হলো না।
চাষির মধ্যে তো evidence complete করে দেখাইছে।
চার্জশিট কিমান জন আছে? ফুল চার্জশিটটো দিয়া নাই।
ফুল চার্জ দিছো?
নাই, লিস্ট অফ উইটনেছ নাই। তাতে লিস্ট অফ উইটনেছ নাই।
আজকে দিছো
বলেছে,
এইটো
কিমান জন উইটনেছ আছে ইয়াতে? এটাতো 4-5 জনের নাম আছে, 5 জনের নাম আছে।
ফুল চার্জ
10 জন উইটনেছ অলরেডি এক্সামিন করেছে। কত ফুল চার্জ এখানে কইতে?
এইটো চার্জ দিছো।
টোটাল কিমান উইটনেছ আছে?
এটা 8টা আছে।
আর 10 জন তো এক্সামিনে হল।
কতজন একজন কইছে? এইটো ফুল চার্জ।
চার্জশিট লিষ্টৰ বাহিৰৰ উইটনেছটো নানে নহয়। মানে let him approach before the trial court because the trial court will be the best.
No, trial court has rejected,
Already
therefore he has.
No, but we do not know present status. He also cannot say what is the stage, whether arguments
No,
are completed
Production
or
of accused,
judgment
my
is
lord.
delivered.
Next date is my lord 12/1/24, my lord. Next date.
12 মানে tomorrow. Tomorrow কি হইছে খবরটা না let it come up day after, my lord. He will find is the status.
Tomorrow is fixed for my lord. Production of accused, my lord.
Argument complete হলো না।
আগুন কোন ধরনের?
কি কারণে?
No, you go through the CIS. At
My
what
lord.
stage it is pending?
My lord, tomorrow is case is fixed for
For
production of
production.
accused, my lord.
That is not for any business of the court.
No, my lord.
But what was the earlier date, last date? And what is the next date?
Whether evidence is closed or whether it is fixed for defense evidence or
No,
whether
evidence is
313
not closed, my lord.
whether 313 examination is completed
no,
or
no.
not.
No completed. Has been allowed not completed. my lord.
Then let a status report be called for, my lord.
My lord, any term and condition I will appear regularly, my lord.
No, you let this court know about the status day after tomorrow. We will.
My lord.
How many witnesses have been examined?
10 witness already examined, my lord.
And at what stage it is pending?
Or let him
And
furnish
how many
certificate copies.
witnesses are there?
Let him furnish certificate copies of the orders after 7/11/23 to me till tomorrow.
What is
Order.
your name?
M. Hawk.
No, who is Habibur Rahman?
Habibur Rahman is the.
He is the accused. Accused.
Okay.
The main allegation against him.
No.
There are,
Other accusations.
there are incriminating material against you. You let this court know about the status of the,
Another date, my lord. Right.
when? How,
Friday, my lord.
heard Mr.
M. Hawk.
M. Hawk, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. On perusal of the scanned copy of the
43.
case record of L Sessions, case number 11 within bracket H/2018, it is not clear as to, as on date, at what stage the trial is pending. Learned counsel for the petitioner has submitted that he may be allowed some time so that he may let this court know about the status of the trial pending against the present petitioner. The prayer is allowed. Let this case be listed again on which date you want?
After vacation,
On 19th,
my lord.
on 19/1/2023.
Item 44.
Petition. Petition. Is this our petition written, no?
May I please your lordship? My lord. 439 application, my lord. FIR at page 11, my lord.
Is there?
My lord, is there is. My lord, in this case, what happened, my lord, one girl of Tamulpur jurisdiction, my lord, she shows her interest and filled a form, my lord, to work in Bhutan, my lord, which is nearest to our Assam border, my lord. And the present petitioner were taking the girl, paying advance of rupees 40,000 to her. And she was going with the petitioner to the Bhutan in the house of the petitioner, my lord. And after some time, my lord, the parents of the girl called her in the mobile phone of the present petitioner and called him to return back, my lord, to the home. Because they decided not to send the girl to the Bhutan, my lord. And as and when the girl was, and the petitioner returned to the village, my lord, then some people gathered there and informed the police, and police arrested him, my lord. And this allegation was leveled allegation that she touched her, the present petitioner touched her body, my lord. Section 376 is there and section 354 is there, my lord. Otherwise, nothing was happened in a car, my lord. But due to changing their decision, my lord, and for a return of money 40,000, this kinds of allegation has been leveled, my lord. Otherwise, I am behind the bar for 66 days, my lord, behind the bar. So considering the period of detention, my lord, I may be allowed. I will cooperate with the investigation, my lord.
Yes.
66 days.
Considering the plea.
Otherwise, materials are there, my lord.
But
Detention, my lord, long detention.
heard Mr. A.K. Azad, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973.
And
Yes.
one thing, my lord, he is outside India, Bhutan national, my lord.
You'll
So
impose-
local surety will be required.
My lord, any surety may be given, my lord.
Local surety has to be given, my lord. One government servant alone.
My lord.
What was the last name? Last word. Has been preferred by the petitioner Ogien Wangchuk, who has been detained behind the bars since 5/11/2023 within bracket for last 66 days in connection with Tamulpur PS case number 258/2023 under section 354A/376 of the Indian Penal Code. The gist of accusation in the instant case is that one that the victim of this case had lodged an FIR on 4/11/2023 before the in charge of Daronga Mela Police Outpost under Tamulpur Police Station, inter alia, alleging that on 3rd November 2023, when the first informant was traveling to Bhutan along with the present petitioner in his vehicle, he offered the first informant to some medicines on when the first informant felt bad, and thereafter he forcefully inserted his fingers in the private parts of the first informant and touched the breast of the first informant. Stop. Learned counsel for the petitioner has submitted that the allegations leveled in the FIR is not true, against the petitioner is not true. And the real fact is that the first informant was engaged engaged to work as housemaid in the house of the present petitioner, and an advance amount of ₹40,000 was paid. However, when the informant refused to work further, the repayment of said amount was sought for by the petitioner, and therefore the false information has been lodged against the present petitioner. On the other hand, learned additional public prosecutor has produced the case diary of Tamalpur PS case number 258/2023 and has submitted that there are implicating materials against the present petitioners in the case diary. However, the investigating officer has also, in the meanwhile, recorded the statement of relevant witnesses, including the victim girl. I have considered the submission by learned counsel for the petitioner as well as learned additional public prosecutor, and have gone through the materials on record, including the case diary of Tamalpur PS case number 258/2023. Though there are incriminating material on record against the present petitioner, however, considering the fact that the petitioner has been detained behind the bars for last 66 days, and considering the progress of investigation already made in the meanwhile, further custodial detention of the present petitioner does not appear to be necessary for fair completion of the investigation of Tamalpur PS case number 258/2023. In view of above, the above named petitioner is hereby allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of learned SDJMS Romya,
CGM Baksha,
learned Chief Judicial Magistrate Baksa, with following conditions. Condition number 1. With above observation, this bail application is hereby disposed of. Send back the case diary.
Highly obliged, my lord.
Item 46.
My please, Lordship. My lord, they were arrested on 12/12/2023, Lordship. On that day, very day, Lordship, there was a gathering, my lord, in front of Mama Bagin Hotel, Lordship. 2 persons were, my lord, inside the gathering, Lordship. The petitioners, my lord, went to visit that my lord, went to see the, my lord, that gathering, Lordship. And many other people was also there, Lordship. The police, my lord, arrested those 2 persons, my lord, along with the petitioners were also taken to the, my lord, police station, my lord. Then, my lord, seized some, my lord, identity cards, Aadhaar cards, etc., Lordship. Then they were forwarded, Lordship. Nothing, my lord, randomly they were arrested, Lordship. My lord, today is 28 days, Lordship. In the affair, no specific allegation, Lordship, against the petitioners, Lordship. From home, my lord, 6 persons were arrested, Lordship. From home, what was happened, what was, my lord, recovered, what was seized, it is not stated. Can you see affair as
at page 9, Lordship. Page 9, Lordship. May I read, Lordship?
Yes.
My lord, from the second paragraph. I have the honor to report that today on 12/12/2023 at 11 a.m., acting on an intel regarding dealing and delivery of fake gold, fake currency at Lalmati area, according to the below noted team was formed, including me, so and so, and self along with the team conducted search operation at Lalmati in front of Mama Bhagin Hotel near IIE office.
What is your name? Name of the.
My lord, name is one is Saddam Hussein. My lord, it's a Dabbash Haldar, Santosh Mondol, Nitai Haldar, and one is Saddam Hussein, Lordship.
How many petitioners?
Four, total 4 petitioners, Lordship. Other 2 persons, my lord, who were, my lord, inside the gathering, Lordship, Manoj Kumar and my lord Shivam Kumar. They were, my lord, surrounded by people, Lordship. The petitioner also went to witness that gathering, Lordship. Well, that is the police randomly, my lord, because the petitioner, my lord, on interrogation, Lordship, they were, my lord, nervous, my lord, the police suspected and arrested, Lordship. My lord, in the FIR, nothing has been stated that it was, my lord, recovered from so and so persons. Just, my lord, recovered from the following persons, Lordship. Who is the, my lord, from whose custody it was recovered? It is not said. Anyhow, my lord, 29 days, Lordship. Thoroughly interrogated, they were taken to police custody, 5 days custody, my lord. My lord, in my humble submission, after 5 days police custody and interrogation, Lordship, nothing remains for further custodial detention, Lordship.
Yes, Mr. Parag.
My lord, CD is available. My lord, he is saying that nothing, only PAN card, voter card is seized. From his annexure, page number 11, my lord, seizure list. My lord, one black color bag containing, my lord, 3 numbers of suspected fake gold, both shape gold, weighing, my lord, 3.56, more than 3.5 kg.
From home.
From whom, my lord, all these persons, I'm coming from the CD, my lord, but my lord, total rupees 1,08,000, suspected to be fake 500 currency of 139 piece and 200 currency 176 piece. Now, from the case diary, my lord, I am showing from his petition, my lord, that seizure list.
Yes, I have an next state, but from whom it was
He is
recovered,
not-
Lordship.
Next,
It
but
is
in
most
the
specific.
argument, he is not disclosing, only regarding PAN card and voter card, he has said.
It is there. There is
And
our documents.
my lord, Saddam is one of the gang, party of one of the gang, my lord. He, along with some other, my lord, went for selling those goods, and other person, my lord, Santosh, Nitai and Devdas, they came to purchase the fake gold. They have been asked by another person, I am not disclosing the name. He says that at low rate, they will provide gold. On that pretext, they have came to purchase that gold. And police have secret information, and on the spot, when the dealing is supposed to be done, at that time, all these persons were taken custody. And Saddam is one of the person, some other persons are also there. And other 3 persons, they came to purchase that gold. And from the position of the Saddam led to the accordingly, these fake note and all these were recovered. So, today, my lord, yes, 29 days is under custody. So, my submission is that, my lord, the FSL is yet to become, my lord, that is not yet received. And there is a, my lord, gang.
My lord,
Saddam is only one person of that gang. Saddam is disclosing one name. I am not saying that the name, my lord, is in the my lord. There are other persons also, my lord, who is doing all this business. They have taken those those items from, my lord, Silapatha.
So
And
you are against granting of bail to Saddam.
Malad, other person also, they have come to purchase
Have-
the gold at low price. So Malad, at low price means Malad, it's fake gold. So others, all three, they have come. But Saddam is a member of the gang. So Malad,
No, what
invest-
material is there against Saddam?
Saddam Malad, he, as per the instruction of another person, he took those items from Lakhimpur Malad and supposed to
Fake
deliver
currency also.
fake currency along with that Malad, fake gold, total 3.56 kg.
My lord, police visited his rented room, lordship. My lord, nothing was recovered from his possession, lordship.
But
Well-
28 days is not much
29 days, lordship.
in fake
Yes.
currency.
My lordship,
We
my lord,
are-
there-
These are crime against the society, Malad. Malad, the fake currency, fake gold, these are Malad.
No, fake gold may not be.
But currency,
an
Malad,
offense. Fake currency is an.
my lord, that too, my lord, from.
Now, what is your
489.
submission?
so Malad, I am opposing all of four, Malad.
My lord, that too, from whom
28
it was
days, my
recovered, it's not stated, lordship. So, my lord, from gathering, it was recovered, the bag was recovered, lordship. My lord, this.
What?
My lord, this honorable court law granted, my lord, on 28 days, lordship. In similar cases, many
These are
cases,
made,
lordship.
made on being produced
My lord.
by the following person.
Lordship.
That the all the names are
Many
given.
orders, lordship. My lord, in my humble submission, 5 days police remand and they were interrogated, lordship, for the purpose of investigation, lordship. My lord, nothing remains, my lord, the further custodial interrogation may not be necessary, will appear if necessary, lordship. Will operate with the investigating officer, lordship, if, my lord, necessary, lordship. My lord, many orders, lordship, passed, lordship, granted on 28 days, 27 days in fake currency, lordship. This is those were clear cases, but in this case, it is not clear, lordship. No,
No, at the time of bargain, Malad, from the statement of the IO, Malad, witness, police witness, Malad, at the time of bargaining, Malad, they were present, Malad. When the bargaining was
Malad,
going on.
one submission is their, lordship. If, my lord, they came to purchase the gold, fake gold, lordship. If they found, my lord, why they did not lodge FIR, lordship? No, they were not complainant, lordship. This is from a gathering, my lord, marketplace, lordship. Not a private area.
Now, what is the stage of investigation?
Investigation, seizure witness, 4 seizure witness examine other.
Now,
those are
what
examined, but,
investigation is going on now?
Malad, that FSL not yet received.
Waiting
And,
for FSL.
and few more persons, Malad, in the group is yet to be, Malad. There may be, Malad, other persons, Malad, that is, has to be, Malad.
What I'm saying, even if, my lord, gold is found, my lord, fake, but then, my lord, my lord, who is the complainant, lordship? Who is the aggrieved? Nothing is there, lordship. So FSL report, my lord.
Fake gold, Malad, they
doesn't-
are the manufacturer. They some of the
FSL
group,
report,
they are manufacturing Malad,
Not,
Malad, material, some materials to be as gold, and they are doing this type of business.
non-receipt of FSL report, my lord, does not, my lord,
No, only 28 days, Malad.
debar, my lord, bail, grant of bail, lordship. Anyway, my lord, 29 days, lordship.
Mr. Parashar, one more query.
Malad.
Why do you require their detention now?
At least Saddam Malad, because he is the, he bring those items, Malad, and Malad, there are involvement of more persons suspected to be Malad. There must be other persons. So that gang has to be Malad unearthed. So at this case, Malad, I am strongly opposing Saddam, and these persons and other 3 persons, they are if doing this type of fake gold business, Malad, they don't have passes for their own, Malad. They will again sold it to other. It's supposed to be, Malad.
Heard Mr. M.H. Ahmed, learned
No
doctor
one
for the petitioner.
purchasing
Also
fake
heard
gold
Mr.
for their own.
K.K. Parashar, and additional.
K.K.
public
Parashar.
person. prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Saddam Hussein, number 2 Santosh Mandal, number 3 Nitai Haldar, and Devdas Haldar, who are detained behind the bars since 12/12/2023, within bracket for last 28 days,
29 days.
29 days in connection with Vashishta PS case number 781/2023. The gist of accusation in this case is that on 12/12/2023, one Rohit Das, SI of police, had lodged an FIR before the officer in charge of Vashishta police station, inter alia, alleging that on that day at about 11:10 a.m., acting on a specific information regarding some dealings in dealing and delivery of fake gold and fake currency at Lalmati area, a search team was constituted and a search operation was conducted in front of Mama Bhagin Hotel near IIE office under Vashishta police station. And the petitioner and the present petitioners, along with 2 other persons, were apprehended with 350 numbers of fake Indian currency notes and ₹1,08,490 rupees in cash, as well as 3 numbers of fake gold boat from the possession of the present petitioners. Learned counsel for the petitioner has submitted that the petitioners were mere onlookers and they assembled in front of Mama Bhagin Hotel after seeing the public gathering there. The public had gathered there to see the other co-accused, namely Manoj Kumar and Shivam Kumar, when the police came there and arrested all of them. It is further submitted by learned counsel for the petitioner that the petitioners are in no way involved in the offense, involved in the offense alleged in the FIR. It is also submitted by learned counsel for the petitioner that the petitioners are detained behind the bars since last 28 days, out of which for 5 days they were in police custody. And considering the period of detention, they may be allowed to go on bail. On the other hand, learned additional public prosecutor has submitted that the accused Saddam Hussein is one of the member involved in the racket, which is indulging in the similar offense elsewhere also. And other 3 accused came there to purchase the fake gold. The petitioner has vehemently opposed the grant of bail to the accused persons, to the present petitioner, mainly the accused Saddam Hussein, on the ground that some other members of the said racket are yet to be arrested. Considering the submissions, I have considered the submissions made by learned counsel for the petitioners as well as learned additional public prosecutor. It appears from the case diary of Vashishta PS case number 781/2023 that the only material against the petitioners, namely Devdas Haldar, Santosh Mandal, and Nitai Haldar, is that they assembled in front of Mama Bhagin Hotel to purchase the fake gold. No other allegation is there against them.
They have other earlier, yes, information, and from the station they went to that place to purchase, yes.
Whereas there are incriminating material against the present petition, against the petitioner Saddam Hussein being involved in the racket, which is indulging in the similar offense earlier also. Considering the submissions made by learned counsel
No
for
such
the-
offense. No
Yes.
case is lawful, yes.
against the present,
Yes, lawful. Earlier there is no case lawful.
considering the submissions, it appears from record that it also appears from the case diary that the investigating officer has in the meanwhile recorded the statement of all the accused persons and other witnesses. And the investigation in this case is mainly pending due to receipt of FSL report. Considering the fact that the petitioners are already detained behind the bar since last
29.
29
Plus 12,
days.
28 days.
And though some incriminating materials are there against the accused Saddam Hussein. However, considering the period of detention already undergone by the above named petitioners, and also the fact that their statements have been recorded, this court is of considered opinion that further custodial detention of the above named petitioners may not be necessary. Report the additional public prosecutor has vehemently opposed the grant of leave. May not be necessary for fair completion of the investigation of Vashishta PS case number 781/21. In view of above, the above named petitioners are allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of Chief Judicial Magistrate Kamrup Metro with following conditions. Condition number 1 and condition number 2. With above observation, this bail application is hereby disposed of. Send back the case diary.
Much obliged.
Item 73 from supplementary.
May it please your lordship, a 439 application, 27 days behind the bar, FI is at page 10, lordship. Can I go through it?
Well, CD not received.
I have my submission, lordship.
CD would be required.
326 and 307, but CD is necessary.
Yes.
My submission is there, lordship. Here, FI is at page 10, Annexure A, your lordship. Can I go through it, lordship? Page 10, Annexure A, your lordship.
Now, do you think without CD,
Lordship, because, lordship,
you have some point that
Lordship.
even without CD?
lordship,
Okay.
lordship, already 27 behind the bar, 27 days behind the bar, and these two, 326 and 307 are added in this, in this case, lordship. 326 would not be applicable here, lordship.
Why?
Because lordship, by going to the city, by going to the FIR, it clearly transpires that lordship, no weapon has been used, lordship.
Blows.
Lordship.
Okay.
And in this regard, I want to place a judgment, Lordship.
Okay, 826 may not be applicable.
Lordship.
307 is there.
Yeah, Honorable, I want to place two judgment, Lordship, one of Honorable Supreme Court and one of Madhya Pradesh High Court, Lordship. And in Madhya Pradesh High Court, Lordship, in paragraph 10, Lordship,
Because, okay,
in while discussing the judgments of the Honorable Apex Court, they are in the Madhya Pradesh High Court. It was clearly held that paragraph 12, Lordship. It is tried law that a penal provision must be constituted strictly that as per the expression language employed, I am unable to hold that the expression any instruments includes kick, fist, or any other body part, Lordship.
no, where are you reading?
Lordship, from the High Court of Madhya Pradesh, Lordship. Annexure 12, Lordship.
Para?
Para 12, Lordship.
Okay,
Page number 3, Lordship.
okay, instrument does not include blow, kicks.
Lordship.
Okay,
And which has been reflected in the Supreme Court judgment in para 15, Lordship.
then what would be the result
Lordship.
if it is not included as an instrument?
Lordship.
Then what would be the outcome?
Lordship. At best here, Lordship,
325.
323 would come, Lordship, 337 would come, and 338 would also come, Lordship. All are bailable offences, Lordship.
What is 325?
Lordship, Lordship, 323, Lordship.
325?
Grievous.
There is no.
307 is there, madam.
No, but only two blows.
Lordship.
Last portion, my lord, of the FIR, it is to be mentioned here that due to grievous injury sustained by my brother-in-law, he was immediately referred to Tezpur Medical College and presently he is fighting for life. That is the, my lord, now he is alive or not. We don't know, my
There
lord.
may be some fracture.
Lordship.
Maybe, my lord.
With that regard, Lordship, I want to
It
place
is
this
necessary.
Delhi High Court judgment, Lordship.
What it says?
In paragraph 12, Lordship. In paragraph 12, here in this case 307 was added, Lordship. Paragraph 12, Lordship. This is also with regard to an accident case, Lordship.
Yes, para 12.
Para 11, Lordship. And the petitioner in this case has been languishing in jail for a period of 2 months. The investigation is over. Custodial interrogation of petitioner is not required, and the search sheet has already been. No purpose may be served by keeping the petitioner behind the bars who happens to be and so and so. The apprehension expressed that the witness may influence can be duly looked upon by imposing adequate conditions, Lordship. Therefore, 12. However, at this stage, it may be appropriate to notice that since the petitioner was not in possession of a driving license, the injured may be faced with a long-drawn litigation for compensation as the liability may ultimately fall on the driver or owner of the vehicle. The rights of the victim in such circumstances need to be kept in perspective. As and when any orders are passed on bail and adequate conditions can be imposed to provide some relief to the victims, Lordship, and secure their interests at the stage of bail itself. The right of a victim does not just merely extend to file an appeal or participate in such proceedings, but much more is required to be done in such cases of accident in order to safeguard the rights of compensation of the victim, who at times is left at mercy of God even to manage the medical expenses at his or her hand. The High Court or Sessions Court at the stage of bail in such cases under Section 439 of the Code of Criminal Procedure may impose appropriate conditions as may be necessary in the facts and circumstances of the case. Lordship, if required, Lordship, he may help the victim also at this point of time. Custodial interrogation at this point is not required.
Accidental case. This is
now as to what injury was committed.
Lordship.
So we don't have materials. though the prosecution is also at fault of not producing the
Yes,
case
that
diary.
is definitely, my lord, yes. Twice we have sent message on,
It was also last listed day before yesterday also.
yes, on 4th of January, it is, we have sent, and again 6th of January, we have sent. Twice we have sent the signal, but we have not received. I think.
He had a valid driving license also, lordship, custodial interrogation, lordship. And he will, if required, he will pay the victim, lordship.
Another short date, maybe, আজি 10 নাই, no?
If required, lordship.
From Vishwanath Malad, yes.
Because the allegation is that he is
Grievously
admitted in
injured
Lakewood Medical Hospital and
Lordship,
fighting
referred
for
to
his
Custodial.
life. So we do not know his condition.
Lordship.
Therefore, case diary would be required. We are fixing a short date.
Day before, day after tomorrow.
Vishwanath.
Tomorrow is also there, day after tomorrow, lordship. Last day after due vacation is there, lordship.
No, will
If
they,
required, he will help the victim also, lordship.
Sorry, then.
will they be able to produce it?
My lord will,
On 4th January, perhaps first case diary was called for.
it is fixed on, Malad, again,
And today is 10th, my lord. Only because of short date, my lord, this is not coming. Because we have to send message through, my lord, SPs
When can you produce it?
on 18 reopening day, my lord.
Your prayer was rejected by trial court after perusal.
Lordship.
yes, my lord.
Day after tomorrow, lordship. Once our lordship, if not come, then it will.
Again.
No, they are saying that it may not be possible to.
My lord, earlier also for 2-3 days gap.
Immediately
CD
on
call.
reopening.
So ultimately CD not received, my lord.
How Mr.
Guwahati.
P.
P.
Bordole, learned counsel for the petitioner, also had Mr. K.K. Parashar. Though learned counsel for the petitioner has submitted that on perusal of the FIR, which mentions that
Urgent likhi
the
dicho.
petitioner
May
has
I
only.
submit, lordship, one thing, lordship. If after vacation, then I may allow to withdraw that. I will try there also, lordship. One-
Yes, that is a better option.
Lordship, because vacation is there, lordship.
Heard Mr. P. Bordole, learned counsel for the petitioner, also heard Mr. P.P. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner may be allowed to withdraw this bail application.
Lordship,
The prayer is allowed.
lordship,
This bail application is dismissed on withdrawal.
lordship. Oblige, your lordship.
Item 74 and 75.
May I please, your lordship?
CD not received, my lord.
Although CD not received, but my lord, may I take your lordship to the FIR, my lord, page 8, my lord. This is the typed copy. If your lordship comes to page 10 format, the FIR is filed on 26, my lord. The vernacular, may I read, my lord?
No. The offense is 376.
The subsequently.
So case diary would be required.
For a moment, my lord, may I take your lordship to the
No,
FIR
these
which I
submissions
filed,
were-
my lord? What is the original fact, my lord? Kindly see.
But these submissions were considered on the first day and court felt that case diary.
No, my lord. These submissions are not made.
And also, my lord.
For a moment, my lord, for a moment, my
Service
lord,
to the, my
kindly
lord,
come to page
other-
21, my lord.
Respondent, my lord.
Yes.
Page 21, this is the FIR which is filed by the
Regarding
accused number 1.
service to the respondent number 2 and 3, my lord. POXO also added back, POXO 6.
Let me submit first.
No, okay, regarding service, I am just.
My lord, the Azahar Kari, Amir Hamza, this is the accused number 1 in the FIR for which I am before your lordship, my lord. And this Amir Hamza This is the husband of the victim, my lord. Elina Begum, my lord. And this FIR is filed on 24, my lord. Sorry, my lord, 25, my lord. This is the actual fact. Thereafter, my lord, subsequently, the FIR has been filed on 26, my lord. সম্মানপূর্বক বিনীত নিবেদন এই যে যোৱা কিছুদিনৰ পৰা মোৰ মাইকী ইলিমা বেগম দিস ইজ দি ভিকটিম অফ দ্য আর্লিয়ার এফআইআর তেখেতে নিজৰ বাপেকৰ
page you are reading?
Page 21, my lord. Page 21 and 21A same. Bottom portion is not clear at page 21, that is 21A, my lord. May I read, my lord?
Now, this FIR is
Filed by accused number 1 of the FIR for which I am before your lordship, my lord.
Okay.
May I read the
Now,
contents?
what do you want to impress? What?
This is the actual fact, my lord.
No, but for that, case diary would be required. You are saying that actual fact is something else.
I'm appearing for the next item, lordship. In this case, lordship, already 74 days has already done. And we have taken steps on the both the victims. lordship.
In both cases, 74 days.
Yes, my lord. As on today, 76 days, my lord. Both the petitioners are behind the bar, my lord. That is why I am submitting, my lord.
In my
No,
case, lordship, I am not.
but
getting
this is the first occasion when case diary was called for. You approached this court late.
My lord. But my friend,
I have appeared, I have.
One
already
case
taken steps,
is 75 is rejected earlier, my lord.
want to reject?
No, rejection are
not rejected.
Not rejected, my lord.
No.
If your lordship consider page
Bilasita.
21,
Bilasita.
the original fact will come before your lordship. Why the subsequent FIR has been filed?
Yes. What is 21?
সম্মানপূর্বক বিনীত নিবেদন এই যে যোৱা কিছুদিনৰ পৰা মোৰ মাইকী ইলিমা বেগম দিস ইজ দি ভিকটিম তেখেতে নিজৰ বাপেকৰ ঘৰত থাকে সো আমিৰ হামজা ইজ দি হাজবেণ্ড ইনফৰমেণ্ট অফ দিস কেছ এণ্ড ইলিমা বেগম ইজ দি ভিকটিম অফ দি FIR ফৰ হুইচ আই এম বিফৰ ইয়ৰ লৰ্ডশ্বিপ তেখেতে নিজৰ বাপেকৰ ঘৰত থাকে আৰু মই ইটা ভাটাত কাম কৰোঁ যোৱাকালি ইংৰাজী 24/10/2020 তাৰিখে সন্ধিয়া অনুমান 8 মান বজাত মই মোৰ শহুৰ ঘৰত যাওঁ আৰু ইটা ভাটাত কাম কৰাৰ বাবে কিছুমান লৰাক আগতীয়াকৈ টকা দিবলগীয়া হয় মুঠ 1,50,000 টকা মোৰ লগত থাকে কিন্তু সেই সময়ত নিম্নলিখিত পদকীয়াগণে মোৰ লগত থকা 1,50,000 টকা লুটি নিয়ে আৰু বাহৰ লাঠিৰে মোৰ মূৰত কোবাই দিয়াৰ ফলত মই অচেতন হওঁ আৰু স্থানীয় ৰাইজে মোক বিলাসীপাৰা হস্পিটাললৈ আনে দিস ইজ দি FIR my lord kindly see the name of the accused persons my lord for that may I take your lordship to page 21A as because at page 21 it is not visible 21A my lord. Accused number 1 Umar Ali, this is the father of alleged victim Elima Begum. Accused number 3 is the victim herself Elima Begum. So what happened, my lord? After filing this FIR by Amir Hamza, the husband of the victim and her father went to police station to file an FIR against the husband, my lord. And in front of the police station, the petitioner for whom I am appearing, he and some other person tried to settle the matter in front of the police station. And therefore, enraging the police personnel, the FIR has been filed. Kindly see the first FIR for which I am before your lordship. It is filed by a police personnel, my lord. Not either by the victim or any guardian. Completely false story, my lord.
No, still the case diary would be required.
My lord, today is 76 days, my lord. For no fault, I am behind the bar, my lord.
And the notices are not yet served.
Notice I think served.
Nobody
I have
has
taken
appeared.
steps, lordship.
And yours,
On 20.
Same person, my
on
lord.
2012, I have taken steps.
Victim is same.
Victims are the same.
So separate notice, I do not think it is required.
it is required. because accused are different. You are wrong in thinking so.
May I just suggest, Lordship? Immediately after the review vacation and date may be taken, Lordship, that the CD may be confirmed. If your Lordship is satisfied that the same is required,
Yes, it
on
is.
18th, Lordship.
My lord.
Will it be
With
possible?
a strict direction that the CD may be produced, because these are all fake cases, Lordship, which you have maintained in this case.
So observation may kindly be given. If CD is not possible, then court may proceed, my lord. That observation may I play. Otherwise, CD will not come.
Court will proceed against whom?
To dispose of the petition.
Then they will not send CD. If you have to produce the case diary, Mr.
No, madam, definitely, madam.
And have you taken steps for issuance of notice?
No order is passed for state, my lord.
Absolutely. Absolutely.
My lord, by tomorrow I will take a step, my lord. Order may be passed.
In bail application number 24. Heard Mr. S. Alim, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. It appears that though the case diary was called for, however, same has not arrived. Issue reminder for case diary. Fixing 18-1 for case diary. It also appears that in the instant case, the notices to the victim / guardian of the victim / support person are not yet been issued. Hence, the petitioner is directed to issue notice to respondent number opposite party, respondent number 3, as per the mode prescribed in the case of Deepak Nayak versus State of Assam by a division bench of this court. The petitioner shall take steps within 24 hours.
Through OC.
Yes, the mode is prescribed. Let this case be listed again on 18-1 for case diary. In next item 75, heard Mr.
P. Decker.
P. Decker, learned counsel for the petitioner. It appears from record that notices issued to, it appears from the office note dated 9/1/2024 that the notices issued to the victim through the officer in charge of jurisdictional police station has been served.
Yes.
It has been. You have taken steps, but
2011.
yes, but notices, there is no report that it has been served or not.
The notices were issued, but with regard to coming back activities that are.
That is required. The service report is not there. That has to be ensured by the public prosecutor, Mr. Parashar.
My lord.
The service of notice on the victim, the OC is responsible to you.
My lord, yes, my lord, but they have to take steps.
They have taken steps.
My lord,
It appears that the
but,
petitioner has taken steps for issuance of notice on the respondent through jurisdictional officer in charge of, through the officer in charge of jurisdictional police station. Learned additional public prosecutor is requested to ensure
My lord, yes.
that the officer in charge of jurisdictional police station to report him back after service of notice on the victim girl. Let this matter be again listed on 18.
No, for CD only, Lordship, along with the CD. Report along with the
Let
CD.
also a reminder be issued for case diary. Let this case be listed again on 18th for case diary.
I am obliged, my lord.
Item 47.
Made please, your lordship. Lordship, it is for the 7th or 8th time, CD not available. Earlier, CD was received, your lordship. After perusal of the CD, the petitioner has been granted interim protection, your lordship. He has also appeared before the learned, he has also appeared before the investigating agency, your lordship, investigation officer. It is for almost last 6-7 occasions, your lordship. Lordship may kindly peruse the order dated 35/2023, wherein interim protection was granted after perusal of the CD.
What is the matter?
Lordship. Lordship will kindly see the affair at page number 8.
No, you tell me the gist of allegation.
Yes. Now, your lordship, this victim who has committed suicide, your lordship, she was residing in her parents' home after leaving her husband due to some dispute with her only son. So when the parent was alive, she was living happily, but after the death of her father, your lordship, she demanded that her ancestral property may be given. But the brother, who is the informant in the case, he was adamant not to give her any property, and he was even trying to oust him. In that process, your lordship, this petitioner and some other local people indulged in the matter and requested him to give her some property because she has no other option to go anywhere else. But ultimately, this lady committed suicide, your lordship, on 15/12/2022. And thereafter, the brother lodged an FIR alleging that I had committed rape with the sister on the previous day, and thereafter, because out of shame, she had committed suicide. So when the city was called for, your lordship, medical report was gone into, and it was seen that there is nothing on rape, and the medical report suggests that it was a case of suicidal in nature. And on that basis, your lordship, interim relief was granted, and I have already appeared before the learned investigation agency also. Lordship will read the affair now for a moment, then it will become clear. He said that on the previous night I committed rape.
No, okay. It is pending since March 23. No longer.
Today I am handicap also. Actually, file is also not given, and CD we not receive. Algapur 140, no?
You have appeared before.
I have already appeared.
Malad may mention that is CD notice even on his prayer that he has appeared. Malad.
Yes.
Heard Mr. M.H. Laskar, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that though the case diary was called for, however, same has not yet been received, and no reason has been shown by the investigating officer for not sending the case diary. It appears from record that by order dated 30/5/2023, the petitioner Kamrul Islam Majumdar was allowed to go on interim anticipatory bail after perusal of the case diary and it is submitted by learned counsel for the petitioner that thereafter the petitioner has appeared before the investigating officer in pursuant to the directions of this court and has cooperated in the investigation. Considering the fact that several dates have lapsed after the updated case diary along with postmortem report. No, when the case diary was perused,
yes,
why it was not disposed of?
interim granted said that FSL report, they said that they want to produce the FSL report, and therefore the court said that, okay, produce the FSL. And thereafter the city is not coming, neither FSL nor city, your lordship.
Okay.
Postmortem report was there, your lordship. There is also
After
indicated
perusal of the
in the order.
postmortem,
Yes, after perusal of the postmortem report, your lordship, nothing 376 not found.
it also appears from record that this anticipatory bail application is pending before this court since March 2023. And considering the long pendency of this bail application, anticipatory bail application, failure on the part of the prosecution to produce the FSL report as directed by this court, and compliance of the directions of this court by the petitioner, this court is disposing of this anticipatory bail application by making the interim bail granted to the present petitioner by order dated 35/2023 as absolute, with condition number 2, 3, and 4 attached to the said order remaining intact. With above observation, this bail anticipatory bail application is hereby disposed.
Obliged, lordship.
48.
She has submitted, madam.
You are on interim.
Lordship,
Yes, in the
interim.
You have appeared before the IO.
Lordship,
Have you appeared before the investigating
Lordship.
officer?
Yes, I will.
Miss, what is your name?
Sashi. No.
P. Borua, Lordship.
Heard Miss P. Boga, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid bearing charge sheet number
76/23 dated 31/7/23.
Lordship, I be protected till
learned counsel for the petitioner has submitted that by order dated 3/5/2023, the petitioner was allowed to go on interim anticipatory bail by this court, and in pursuant to direction of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. Considering the submissions made by learned counsel for the petitioner, the interim bail granted to the present petitioner by order dated 3/5/23 by this court is hereby made absolute, with condition number 2, 3, and 4 attached to the said order remaining intact. With above observation, this anticipatory bail application is disclosed.
Item 49.
49 also. Sashi.
I'm on interim, my lord.
Have you appeared?
Yes, my lord.
Heard Mr.
You Khan.
Yu Khan, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who has submitted that the investigating officer has already laid the charge sheet bearing charge sheet number
352/23 dated 26/7/23.
Learned counsel for the petitioner has submitted that by order dated 19/6/23, the petitioners, namely Manwar Ali, Mahibul Haq, and Abu Talib, were allowed to go on bail by this court, allowed to go on interim bail by this court. And in pursuant to the directions of this court, the above named petitioners have appeared before the investigating officer and have cooperated in the investigation. Considering the fact that the petitioners have complied with the directions of this court, the interim anticipatory bail granted to the above named petitioners by order dated 19/6/2023 is hereby made absolute with condition number 1, 3, and 4 attached to the same order remaining intact. This anticipatory bail petition is accordingly disposed of.
Obliged.
Item 51.
51 मतलब reason interim but CD not receiving.
I am an interim, Your Lordship. I have appeared, Your Lordship.
The
Fiction मतलब 29 of January.
heard Mr. UK
R4, Your Lordship.
R. Core, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, who submits that, who prays for some more time for producing the case diary. The prayer is allowed. Let this case be listed on
29th of January.
29 January. The interim order shall continue till next day.
Item
Obliged, Your
53.
May it please, Your Lordship.
Is there, no?
So we already appeared, Lordship, after getting the interim, Lordship. FIR is at Lordship 14, Lordship. 9, Lordship. Okay, this is. I think so.
Yes, Mr. Das.
Well, yes, case there is similar shows reverse heart. One finger is amputated, my lord, due to cutting injury inflicted by him. They have cooperated with the investigating officer. my lord.
Heard Mr.
M. Mondal.
M. Mondal, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. Learned counsel for the petitioner has submitted that by order dated 5/12/2023, the petitioners, namely Sanwar Ali, Sanwar Hussain, Abdul Samad, alias Abdul Samad, Mustafizur Rahman, Mozuil Haq, alias Mozair Rahman, and Mosharraf Hussain, alias Mosharraf, were allowed to go on interim bail by this court, and in pursuant to the directions of this court, the above named petitioners have appeared before the investigating officer. Learned additional public prosecutor Mr. D. Das has produced the case diary of Mankachar PS case number 309/2023 and has submitted that though there are incriminating material against the present petitioners in the case diary, however, it appears that they have complied with the directions of the court and have appeared before the investigating officer, and their statement under section 161 CRPC have also been recorded. Considering the fact that the petitioners have complied with the directions of this court and have cooperated in the investigation, the interim anticipatory bail granted to the above named petitioner by order dated 5/12/2023 is hereby made absolute. And absolute.
Item 54.
May it please your lordship. This is anticipated bail applications, my lord. And interim was granted to me and I have appeared before the IO, my lord. And it is called for. What are relating to Erekanath, seizure of Erekanaths, my lord. And I am the owner of the vehicle.
Have they appeared? Have they appeared?
No, regarding that, no statement of the my lord accused person is available in the case diary. CD is up to my lord 7/12/23, and on that date, my lord interim granted me.
You have appeared before IO.
IO and vehicle also hand over. Because there is a order of.
Otherwise, my lord, implicating material in the case diary, my lord.
No, but vehicle has been given in Jimma.
My lord.
No endorsement to that effect is there in the case diary.
Regarding that effect, my lord, there is nothing in the case diary.
Updated case diary would be required.
Yes, sir.
Now, Mr. M.A.I. Hussain, learned counsel for the petitioner, who submits that the petitioner was granted interim anticipatory bail by this court by order dated 7/12/2023 And in pursuant to the directions of this court, the petitioner has appeared before the investigating officer. On the other hand, learned additional public prosecutor has produced the case diary of Merapani PS case number 52/2023 and has submitted that the case diary is updated only till 7/12/2023, and on perusal of the case diary, it cannot be said as to whether the present petitioner has appeared before the investigating officer or
Yes, sir.
not. Hence, he prays for updation of the case diary. The prayer is allowed. Let the case diary be sent back to be called again after updation on
My lord, 9th of February, my lord.
on 9th of February.
Yes.
The interim order shall continue till next day.
55.
My pleasure, lordship. In this case, your lordship, I think CD is not there, but there is no interim, your lordship.
But 376 is there.
376 is there, your lordship, but the FIR loss in the year of 2019, alleging the incident which was occurred in the year of 2017, your lordship. This 8 is the FIR, your lordship.
When FIR was lost,
2019,
since then you are not arrested.
no. But the incident took place in the year of
Then let us
2017.
wait for the case then.
But I am,
We
if
have
it's
to.
possible, your lordship, then interim, your lordship may be given so that we may give our statement, your lordship. But
Yes, case diary is there.
No, my lord, case diary is not available, my lord.
You produce it on the next date.
Yes, ma'am, yes.
When can you?
On
Because they
my-
are not on interim.
Then on
and
my lord,
today is the second occasion, your lordship.
on the day of opening, my lord, on 18th of
Will you
January.
be able to produce?
Then on 22nd of January, my lord. On that
Let
day,
it be on 22nd.
22nd.
Heard Mr. A.M. Khan, learned counsel for the petitioner, who submits that the petitioner is not on interim and the FIR in this case has been lodged after a delay of almost 2 years. However, as by earlier order, this court directed for the perusal of the case diary, same would be required. On the other hand, learned additional public prosecutor submits that he may be granted some more time to produce the case diary. The prayer is allowed. Let this case be listed on 22nd January
Yes, ma'am.
for case diary.
All right.
For 30th application, my lord. Case diary was called for, my lord. I'm not immediately. Should you available? 30 point. FIR is at page 15, my lord. It's a long FIR, my lord. My name is not there in the FIR, my lord. But I'm apprehending arrest because that person who was caught, my lord, in this scam, he was my driver, my lord.
What is the allegation?
Allegation is, my lord, 120B, 420, 406, 467, and 468, my lord. Purchasing bike from a dealer and then in a good condition, my lord, and then they used to sell or they used to sell to the other states, my lord. That is the allegation, my lord.
No, what? You purchase bikes from,
From the dealer, my lord,
then
and then sell it to the other person, my lord.
where is the
Without
offense?
giving EMI, my lord. That is the allegation.
Without giving EMI.
What is there in the case that I don't know, my lord, but that is the allegation, my lord. During interrogation of property. During interrogation of property. Yes, sir. The relevant part is, my lord. During interrogation, Mr. Sabas Ali Rahman, Ria Khan, and Mr. Dick Raskwa were continuously engaged in third-party person to buy costly motorcycle by providing their personal documents, pay low down payment from different showrooms with intention to cheat the financial company. And they take over those motorcycles from the third person by giving some money and sold those motorcycles to other states outside Assam, such as Nagaland, Meghalaya, no matter.
What is your name?
My name is Karanjit Laskar, my lord, but my name is not appear in the FIR, my lord.
Then why are you apprehending?
That person who was caught, my lord, that Dipan Das, he was my driver, my lord.
Dipan Das is also not a named accused.
Yes, my lord, but it is there in the forwarding list, my lord. In the forwarding report, my lord, page 22 to 24, my lord. There it's appeared, my lord. The fifth person, my lord.
Where?
The Dipan Das.
24, please.
Page 24.
No, facts, you have to be clear.
Yes, my lord.
You have to tell the facts like as if you're telling a story to the court.
My lord.
Because I have not understood your story.
My lord. That person who purchased the bike from the dealer, my lord, he happened to be my driver, my lord, from Nagaon, my lord. I am the resident from the Nagaon, my lord. He happens to be my driver.
But where your driver has been implicated, your driver was also not named in the FIR.
Not named in the FIR, but he was arrested, my lord, from the dealer itself, my lord. It is in the forwarding list, report, my lord, in page 22, 23, my lord. In the petition, my lord. Forwarding to the last.
Where is the statement that that driver disclosed your name?
It may be in the
No, but why he has appeared?
my lord.
You approach this court
Yes, my lord.
praying for anticipatory bail. You
because-
must be apprehending your arrest.
Because police was searching me, my lord, in my residence, my lord, in the Kampur. I am from the Nagaon, my lord. The FIR is from Gitanagar only, my lord. But police has come to my residence, my lord.
As your driver is also arrested, you are apprehending that your
Yes.
driver might have
Yes,
disclosed your
my lord.
name. Okay.
That's what, my lord. I don't know whether my name is there or not.
Yes,
That's
Mr.
one
Das.
statement, my lord.
Yes, Lordship, here the persons, this is.
Three persons were named in the FIR.
Lordship.
He is not the named.
He is not in the FIR, but this in the FIR, there is one third party is there, Lordship. And in that third party, his role is of that third party only, Lordship. I will go into that condition, circumstances, Lordship. What happened, Lordship? This person, Sabbas Ali and Miss Ria Ahmed, they were in their house, found, Lordship, 350 motorcycles in new conditions with a number plate. When police interrogated, investigation goes on, Lordship, then the police have found that these persons engage third parties. And these third parties' role is that they collect different persons for Lordship. In their name, they buy these bikes, Lordship. And with their involvement, my lord, what they done, they take the finance has been taken, Lordship,
And
loan. Then after paying only 2-3
they default.
installments, Lordship, they defaulted. And they have sold that bikes have been sold to this person, Lordship, these two persons, Sabbas and Miss Ria Ahmed, Lordship. They sold it to Nagaland, Bangladesh, these things. And they showed it that this bike has been lost. And they took insurance money also, Lordship. After showing that they had lost money, and this person's name is there. He is the one of the third party, my lord. He helped this person to get this
No,
person.
what is the allegation against Karanjit Laskar?
Karanjit Laskar, he provide this person's Lordship, who Lordship, his involvement is that he, Lordship, collect these persons and in their name, he buy this document, lordship, vehicles and sold it to this person. And he, in that condition, he got commissions, lordship.
No, no, neither the petitioner nor the prosecutor are able to tell me this story.
Lordship.
I'm not understanding. I
Lordship.
want to know the specific role of
Mhm.
the petitioner. What is the allegation?
Lordship, it is there in the CD, lordship. His name is also there.
Now, what is your submission?
My submission is that he is one of the third parties. He give, provide my lord, this kind of, he collect these persons. And that allegation is also that these documents are fake. He said finance companies also, lordship.
So intentional indulgence is in defrauding the
Lordship.
financier is there. Then you will not be getting anticipated. Rent.
Yes, my lord.
That is lordship.
Heard. Mr. D. Borla, learned counsel for the petitioner. Also heard. Mr. K.K. Glass, learned additional for the prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Karanjit Laskar, who is apprehending his arrest in connection with Gitanagar Police Station case number 312/2023 under section 120B/420/406/467/468 of the Indian Penal Code. The gist of accusation against the present petitioner is gist of accusation in this case is that one Deep Jyoti Chaudhary has lodged an FIR before the officer in charge of Gitanagar Police Station, inter alia, alleging that after receipt of an information through reliable sources that one Shabash Ali and Ria Khan are involved in the incidents of motorcycle theft, and a search operation was conducted in the rented house of Shabash Ali at house number 34, Ambikagiri Path, and during said search, said such 37 numbers of 330 numbers of helmets, one black color Royal Enfield classic motorcycle without number plate, one Yamaha motorcycle, one black color TVS Northrop motorcycle without number plate, one Jupiter TVS Jupiter bearing registration number AS33 AS A0218, along with cash amounting to rupees 1,37,000 were recovered therefrom. During interrogation, it was revealed by the accused persons, namely Shabash Ali and Ria Khan, that they engaged third-party person to buy costly motorcycle by providing their personal documents, by paying low down payment from different showrooms with intention to cheat the finance companies. And after they take those motorcycle, the third party persons, by giving some money, they used to sell that motorcycle in other states outside Assam, such as Nagaland and Meghalaya, and never pay back their EMIs. Learned counsel for the petitioner have submitted that the petitioner is no way involved in the offense alleged in the FIR. However, the police is searching for him, and therefore he is apprehending his arrest in connection with this case. He has also submitted that the driver of the present petitioner, namely Deepan Das, has already been arrested, and he suspects that the driver might have implicated his name in this case. On the other hand, Mr. K.K. Das, learned additional public prosecutor, has submitted that the modus operandi that there are has produced the case diary of Gitanagar PS case number 312/2023 before this court, and has submitted that there are sufficient implicating materials in the case diary against the present petitioner, and he has vehemently opposed the grant of anticipatory bail to the present petitioner. He has also submitted that the modus operandi of the petitioner and his group and other accused persons named in the FIR is that they used to take loan from the finance company in the name of third party, and by paying a very low down payment, and thereafter they default in the making payment of the loan, and they sell their motorcycles to the persons outside the state of Assam, and thereby they used to defraud the finance companies. Considering the fact that there are incriminating materials in the case diary against the present petitioner, this court is not inclined to grant benefit of an order under section 438 of the Code of Criminal Procedure 1973 to the present petitioner at this stage. This anticipatory bail application is accordingly dismissed. Send like this.
Obvious, man. Deeply.
Yeah, please, Your Lordship. My lord, put 38 application, my lord, interim protection was granted, my lord, and I have appeared before the IO making a statement, my lord, in compliance of this our court order. My lord, page 12, annex 2 is there.
You are a lady.
I am a lady, my lord.
She is the
Please.
mother of the main accused, Raqibul Islam, my lord. She is responsible for committing the offense of 376, and because of that, my lord, the victim became pregnant, and my lord.
He is not responsible for
The present accused person, there is allegation against the present accused person that after pregnancy of my lord 22, the my lord victim gave miscarriage of her fetus, which was 5 months old, as stated by doctor of so-and-so, my lord, and for miscarriaging of that my lord 22 months my lord fetus, the present accused person is responsible. That is the allegation, and my lord, the present accused person took her to a my lord medical center with the help of one ASA worker in a medical center at Borpeta Road, and thereafter, my lord.
Who is the victim? He is known to them.
Yes, my lord. Because, my lord, as per 164 statement, she has that she is having love affair with the, my lord, one Raqibul Islam, the son of the present, my lord, petitioner, and thereafter, my lord, she, she also stated in 164 statement, my lord, she committed the offense of 376 forcefully, my lord, against her will, and for which, my lord, she became pregnant, and thereafter, all these things happened, my lord.
No, Lord, may I submit, my lord?
Oh, now what is the submission?
My lord, she appeared.
Her statement has been recorded.
Statement not recorded, but she appeared before the IO. That is the note of the IO, my lord, along with one advocate.
It is the duty of the.
But
My
her
lord,
statement
on
was.
the other day, my lord, 5th of January, my lord, the name accused, my lord, two accused name, father and son, my lord, Raqibul Hussain is the main accused who did the, as per allegation, the 376.
But allegation.
And in respect of other accused, number 2, this honorable court, my lord, granted bail, my lord, though for 439. On the other day, in the other court, my lord, after perusing the case diary, my lord, the honorable court asks whether there is a ultrasound or any proof of the removal of fruitas, ma'am. Because this is absolutely not correct, my lord. Yes, it is admitted that the Raqibul Hussain and the
Okay, no, they
victim
are
had
not,
a affair.
they are not praying for your custodial
Yes,
interrogation.
Already cooperated.
Heard Mr. A.K. Hussain, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner was a petitioner who is a
Just like to point out that ultrasonography report is available. Madam, at that point, she was pregnant of 22 weeks and 3 days. That is, madam. And later on, madam, she gave birth to a madam dead fetus of because of the madam death. For that, madam, who the present case person is responsible.
learned counsel for the petitioner has submitted that the present petitioner, who is a 55 years old lady and mother of the main accused, namely
Raqibul Hussain.
Raqibul Hussain, has already been allowed to go on bail of already been allowed to go on interim bail by order dated 14/12/2023 by this court. And as per directions of this court, the petitioner has already appeared before the investigating officer and has cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Govardhan PS case number 179/2023 and has submitted that though there are incriminating material against the present petitioner of having committed offense under section 313 IPC, however, she has already appeared before the investigating officer and was allowed to go on interim anticipatory bail as per directions of this court. Considering the fact that the petitioner has appeared before the investigating officer as per directions of this court and has cooperated in the investigation, the custodial interrogation of the present petitioner does not appear to be necessary for their completion of the investigation of this case of Govardhana PS case number 179/2023. In view of above, the interim bail granted to the present petitioner by order dated 14/12/2023 is hereby made absolute with a condition that with following conditions, condition number 1 and condition number.
My friend, item number 78, it's the bail application, he is in custody. 78.
All are in custody.
No, others are AB and only one, there is only one bail application. He is in jail.
No, what do you want?
So if,
Me to continue?
yes, sir.
I will not continue
My lord,
because this will set a wrong precedent for me. I will fail in my own trap.
my lord, item 61, my lord, to the orders, but item 61, there the parties
No,
to the
before that, which item number is it?
78. This is last item.
70th case diary.
Case diary is available.
We'll take up 78 tomorrow as the first item.
Yes.
My lord,
item 61, my lord, for orders. It pertains to the interim stay of sentence in my lord bail, my lord, in a criminal appeal which was admitted by your lordship. So today it was fixed and expected, it may come, I know, 19 on Friday, my lord.
Okay.
19 on Friday because of the. After
19, item number?
For orders again, it will come.
Item number?
Friday 19.
What is item number?
Item number
61.
61 on Friday.
61, my lord.
My lord, 62 also Friday, my lord.
Friday again this will happen.
my lord,
No.
my lord. My item is 67. My lord, it is already over, my lord, because affidavit has been submitted by the forest department. It may be fixed top of the list on 23rd, my lord. Formal order is only required.
23rd.
No, this is a bail court.
No,
If,
hearing, today was fixed for hearing.
no, bail matters have to be given precedence over any other matters.
Because several dates it was fixed, it was not reaching, my lord. That is the problem. He is a PhD holder. Only for this he is hanging. He is getting some job somewhere. And this has become a handicap. Forest Department has admitted that whatever position he had, it was duly authorized.
67 on 23rd at 2 p.m.
My lord,
39
60
item number admission, lordship. I prepared that let the matter come on 23rd, lordship.
My lord, 62 is a quashing matter, my lord, on several occasions listed, but not reached. My lord, and there is no stay in lower court proceeding, my lord. So it may be taken on Friday or
Friday, it may not be possible. After we go.
22nd, my lord.
Okay.
62. Item 62. 22.
Well, with regard to item number 37, my lord, that is maintenance matter, my lord. May have to come after the vacations, my lord. Only praying for a date, my lord. Matter has been settled, my lord. 37.
Now rest matter, court master will give dates. If it is
There is
not-
one request, my lord, with regard to item number 60, my lord. We may be granted a liberty to collect the tracking ID from the registry, my lord. That only will.
What?
60, my lord. Item number 60, my lord. Orders for orders.
You want?
We may be granted a liberty, my lord, to collect the tracking ID from the registry, my lord.
On request of learned Mr. S. Das learned counsel for the petitioner is granted liberty to collect the tracking ID of the notice issued to the respondent from the registry.
My lord. Highly obliged.
37 is fixed on, well, any date.
That is,
Item number 37. Any day after the vacations.
let the court master gives.
Man.
That may be fixed, my lord, otherwise.
6.
62.
You make prayer before the court master, remaining as per your convenience.